It's 10:03 a.m. and I'm going to call this special meeting of the Task Force on Mandatory Minimum Sentences to order. I appreciate everybody coming out today. This wasn't normally a normally scheduled meeting, but we did need additional time to finish the important work that we began in our June meeting. And I appreciate everybody's willingness to fit this extra meeting into your schedule. Don, would you please call the roll?
Shane Baker. Shane Baker is not here. Jeremiah Carlson.
Here.
Jeremiah Carlson is here. John Donovan.
Here.
John Donovan is here. Mark Hazy.
Here.
Mark Hazy is here. Dale Harris. Dale Harris is not here. Amber Johnson.
Here.
Amber Johnson is here. Kelly Mitchell.
Here.
Kelly Mitchell is here. Mark Osler. Mark Osler is not here. Nate Wrights.
Here.
Nate Wrights is here. Ken Sass.
Here.
Ken Sass is here. Nick Sasser.
Here.
Nick Sasser is here. Robert Stewart.
Here.
Robert Stewart is here. Ashley Stewart-Griffith.
Here.
Ashley Stewart-Griffith is here. And we do have a quorum.
Thank you, Don. We do have next on the draft agenda here, approval of the June 12th minutes in today's agenda. Did everybody have an opportunity to look at the June 12th, 2026 meeting minutes? And, because this is a special meeting, if we wanted to, we could defer this until the next regular meeting if you wanted to and approve both minutes at the same time. But if folks have had the chance to review this, I will admit I've been on vacation, so I haven't had a chance to. But if there have folks had a chance to review this?
Yeah, I had one note.
Okay.
I mean, it's small, but just at the very beginning, it said members absent has Jeremiah Carlson, which I think is correct. But then under the roll call, it says that Jeremiah was here. It's a small thing, but if you wondered if people do read them, I do. So
Well,
that would be my one note for the minutes.
and I noticed that Jeremiah is spelled differently in those two spots as well. So was Jeremiah present or absent?
He was not present at the last meeting.
He was not present. So so with that correction then would be to spell Jeremiah with two E's in the members absent line, and to, well, actually then there would be 5 members absent, wouldn't there? How does the math work on this? Yeah, I don't think those numbers are quite adding up either. Let's see, 1, 2, 3, 4. So it looks to me like there's 4 members attending virtually, 5 members absent, 3 members in person. Is that what you got to?
Yes.
Okay.
While we're making those corrections, my last name is spelled wrong. It's Sassor.
Oh, excellent. Thank you, Nick. So correcting the number of members attending virtually, correcting the number of members absent, correcting the spelling of Jeremiah and Sasser in the absent line, and deleting Jeremiah Carlson from the roll call. Are there any other corrections to the June 12th, 2026 meeting minutes? All right, Don, do you have all those corrections? Okay, so hearing no other corrections, then the meeting minutes of June 12th, 2026 will stand adopted as corrected. Any changes anybody would like to suggest to today's agenda? Yeah, we really have a lot to do today. Somebody did bring up the question, I guess while I was on vacation or while I was focused on getting ready for the things I needed to do while I was about to go on vacation of, is it really necessary for us to get into this detail? Is it really necessary for us to essentially draft very specific policy language such that it could be made into a bill? Or could we just give the legislature kind of general ideas of sort of policy philosophies that we believe, should be in place with respect to mandatory minimums? And I'd be very curious. I know, Mark Hazy, you've spent a lot of time in the legislative space, and I'm wondering if you agree with me on what I'm about to say, or anybody else who's had such experience. But I know Mark has worn out a lot of shoe leather in the Capitol complex, and you know, uh, two things about several things about the legislature. One is they're very busy, and while they're perfectly able to change something that exists, they probably don't have time to create, or probably not the expertise either, to just create something out of scratch, just from principles. And as hard as it is for us to believe this, we probably have more time than the legislature has, to devote to this particular issue. The legislature has quite a bit of time, but they also have a ton of issues that they have to get through, and deadlines and all that sort of thing. And so I think the more we can get done as far as being very specific, and I know that means getting into the weeds and you know, uh, maybe getting a little bit messy as we get into the weeds, but the more we can do for them and ultimately create, I would hope, bill language, the better the chances will be that this task force actually comes up with something that makes a difference. And by makes a difference, I'm not saying there isn't something inherently good about meeting together and discussing things and speaking the truth, but as far as changing the policy that exists for the better in the state of Minnesota, that I think the best way we can accomplish that is by actually coming up with a concrete proposal. Another thing that we have right now that we will lose on August 15th when we disappear in a puff of smoke, or August 16th, I guess, if we file the report on August 15th, is we lose the resources of the revisor's office to help us with the bill drafting, but also create a bill jacket, create something that a member of the legislature could then say, that sounds good to me, sign me up, I will sponsor that bill, I will author that bill. If we don't have something jacketed like that, we're basically asking the legislatures to do that themselves, and that's a pretty big lift, especially since a particular legislature may not even have the experience or expertise in this particular area, but nevertheless have passion for the things we're trying to accomplish. Mark, I'm wondering if you have any, or anybody else has any comments on that, or kind of corrections of sort of how the legislative process works.
No, I totally agree with that, Nate. I think this is a pretty technical stuff we're looking at, and you have a lot of the experts, or people who have some expertise in this group here, and they can always change it. It's like, if your boss wants you to write something, you're not just going to give them outline, you're going to write it, and they may edit it, but it saves them a lot of time to have something they can start with and go from there. It very, very much speeds things up to come up with something specific.
Yeah, and to that point you made, I do agree that the legislature is very capable of changing something that somebody else wrote. I mean, they definitely have their own opinions, but the likelihood of just asking them to create something out of nothing, I've seen that fizzle every time I've tried that with.
Yeah, and you never know what you're going to end up with after it goes through
Right,
sausage
for sure.
making, as they call it. And so the
Right.
more specific you can be, probably the more likelihood you have of it becoming something that, folks agreed on.
Jeremiah?
Yeah, I was just kind of curious if, obviously, that really only leaves us today's meeting and tomorrow's meeting to accomplish this task of getting real deep down into the weeds here. Is this something that if we were to present what we have as a report and say it's unfinished work, and again, I guess it's kind of up to the committee how they feel, that we then spend that next year cycle trying to really hammer out more concrete? So we are presenting something that is been thoroughly thought through and kind of rushed through to make sure we got to the deadline before we lost our resources.
I mean, if that's, if in going through these decision points, that's the will of the task force, like we just don't have enough information to make a decision like this, we could do that. But I think we've already spent quite a bit of time on it. I will say I've been on other task forces or advisory groups or working groups that were given less time than we've been given to deal with this. Basically, the legislature says, give us something by next session. So they want the report done in January, which is, understandable from the legislature's point of view, but it's really hard for a task force to whip something together that quickly. So we have been given a full year. I guess I'd like to see what we can do with the time we have. Really, I mean, this is the meeting where we're trying to come up with a tentative agreement. And then based on this, what happens at this meeting, and I'm talking about today, Jeremiah. So the next meeting is next week, right? It's not tomorrow. So that's the regular July meeting is July 10th. Based on what we decide today, I'm going to ask the staff of the Minnesota Sentencing Guidelines Commission, the research staff, to come up with the impact numbers. And I'm going to try to come up with final language. I'm going to run it past the reviser. I don't really expect that the reviser will be able to come up with final language by July 10th, but possibly she will. And that would be great. But we're gonna kind of look at the preliminary decisions that were made today and see what we want to do based on the numbers that we look at in July, whether that's going to be our final decision. So for a recommendation to the legislature. So yeah, it really is today that we're going to try to come up with the preliminary recommendations.
And Nate, for things that we don't have complete consensus on, how are we going to handle that? Are we going to have folks have an opportunity to say, have in the report they disagreed and why? That's something we still need to figure out.
Yeah, I think we'll have to see what the votes look like, but yeah, as far as what that'll look like, but and consensus is a squishy word too. How many people out of a 13-member task force is consensus? Is 8, is 9, is 10, is 11, is 12, is 13? Is that what you require for consensus? So yeah, it's good questions, but let's see what we get here, continuing on in the process. So I'm gonna pass it back to you, Julie.
Good morning. I think that everyone should have the decision point discussion guide marked July 2nd. It's an updated version of what was distributed on June 12th. We tried to revise a few things to make it a little bit easier to, synthesize it a little bit. But we also have on page 2 the votes. So for those of you that weren't able to attend and or just were attending and wanted to see kind of where we landed, this was the summary of how we calculated the voting. We also made the voting sort of loose. It wasn't like an official vote, But we did make it through the decision point 1-1 through 1-4 and started getting into decision point 1-5. So I planned to pull up the PowerPoint, but if everybody has the guiding document with them in front of them too, that would be great. If not, I don't know, is it on the webpage yet? Is it what are these documents on those?
Yes.
Okay, so you could, we can, you can find it there, and maybe Sophie or Jennifer could paste the link in there in case you don't have it easily accessible. But I was going to pull up the PowerPoint here and then just go through, as we did last time, go through each slide to have discussion. And we'll break for, giving opportunities to kind of pause when we needed to. So let me make sure I have this pulled up right. Hang on a second. Okay. So for each decision point, our plan will be to talk about if we're ready for a recommendation, if there's anything that needs revision or clarification, what kind of, maybe new or more information is needed. And that's sort of how we approached the last 4. And we have kind of 3 general discussion point ideas with a lot of detail in them. We started with the weapon enhancement reform, which we'll continue talking about today. All of these we're going to hopefully talk about today. I think that we've started with the more complex ones. I say that just because there's more decision point 1 dashes than there are 2 and 3s, but I know there's complexities in all of them. So, but we've started with the one that has the idea that has the most things to look into. And we will jump into, so this was what I was just mentioning on the page 2 of your, from the discussion of June 12th. And I think I don't know if we need to pause here to talk a little bit about, we didn't have a formal vote for the weapons involvement, decision point 1-3. So there's some things that weren't resolved, but I'm wondering if we might just move on to the 1-5 and then come back and revisit everything, that just so at least we can make sure that we cover the discussion of the rest of the 16 decision points.
The chart always, I have to take a couple steps in my brain to make sure I know what we're talking about. But option A, it's like, what are the option A's, option B's, or maybe that's on the next page and I should just shut up.
Thank you for saying that, Kelly. It is on the next page of your decision point document. It is, and perhaps I should have pulled that up as well, because I don't think we summarize it on this next page here. No. So, yes. So for decision point 1, option A was yes, we need a new framework. And option B was yes, but 60911 accomplishes this. And then option C was no, we don't need a new framework. So the people who everybody said we need a new framework. And that was for decision point 1-1.
Okay, thank you. That's helpful. I get it now.
For option 2, everybody felt that the incorporating sentencing guidelines, that the vote summary was using sentencing guidelines as a foundation. That was an agreement. So members agreed that the sentencing guidelines already account for criminal history and offense severity and should serve as the foundation for any new framework. There was no support for creating an entirely separate system or ignoring these factors. For the ranking weapon involvement conduct, there was no formal vote taken. Members agreed conceptually that weapon involvement should be ranked from the least to most serious, progressing from possession to discharge. However, we didn't come to a consensus about the number of tiers, the level of detail within tiers, and then the definition of certain categories like off-person possession.
I would say some of that will probably come out in the wash when we get through the details on 1-5. We can kind of keep the draft tiers from 1-3 in mind as we look at 1-5, but ultimately, if people don't think there's a meaningful punishment distinction to be made between, say, dangerous weapon possession and or other dangerous weapon use and firearm possession, then sort of by de facto, those are then on the same tier. So.
Okay, good idea. So we'll keep that in mind as we look at 1-5. In terms of the accomplice liability, we didn't take a formal or final vote, but option B emerged as the leading direction. And I don't have what option B is here. Let's see. The discussion moved away from automatic equal punishment for accomplices, which was option A. Most members seem to favor a knowledge-based approach in which accomplices would receive similar punishment only when they knew in advance that a firearm would be involved. So preference for a knowledge-based or hybrid approach with judicial discretion, and then the final decision was deferred. Do we want to move to talk more about 1-4 or?
I mean, it seems like something we could discuss as a standalone thing, and maybe it's kind of a good, I hate to minimize the seriousness of this topic, but maybe it could be kind of a good warm-up topic for us to discuss.
So I want to pull up the slides from before so we can look at those. Stop sharing for a minute.
Just while you're doing that, just by way of background, the status quo approach is that whatever the accomplice does with the firearm is treated as if the defendant had done it with the firearm. So it's really, I think that was option A, as you described it, that there's really 100% liability for any firearm use that an accomplice does, even if the firearm use isn't an element of the crime and the defendant who was culpable for the underlying crime it was really unwitting as far as the firearm use went, or other dangerous weapon use or possession.
Dr. Stewart, you have your hand up. Oh,
I just have a quick question related to Nate, what you had brought up earlier in terms of putting something together for the legislature at the end. I'm wondering if, because there was, it seemed like there was support for 1-2, which was, should we incorporate the sentencing guidelines recommended sentences into this new penalty framework? I'm wondering if it would be worthwhile to consider jumping to 1-8 to talk about whether or not we think that the sentencing guidelines commission should be trusted with kind of converting these statutory maximums and whatnot. I guess what I'm thinking is, in terms of what an end product looks like, if there's, widespread support for this becoming something that becomes the purview of the sentencing guidelines rather than statutory set out maximum or mandatories like 60911 currently has. Whether that might shift the level of detail and whatnot that we'd have to put into it, because like you said, the legislature may not have a ton of expertise on this, but but the Sentencing Guidelines Commission obviously does, and it's made up of a wide array of experts who can and spend a lot of time talking about these things. And so that if we do think that the end product of this would be to tell the legislature that this is something that should be moved to the guidelines, then recommendations could be focused on providing, general guidance to the guidelines as opposed to like in the weeds, to let them kind of hash out on a less limited timeline than what we currently have.
Mhm.
Just throwing that out there.
Yeah, that's super interesting.
It's an interesting, Rob, this is Kelly. It's a really interesting idea you have there, because I think about the fact that like when we were talking last week about or whenever that was, 2 weeks ago, about the seriousness of the action, like is it possessing a gun but not in control, something that they can know, is it bringing a gun to the scene, is it actually firing the gun during the offense or while fleeing from the offense. We kind of had general agreement on that progression of seriousness, and I could see a situation where like we're saying to the legislature, anything the Guidelines Commission does needs to account for these differences in firearm use, right? And there could be a bit more general law crafted as direction to the commission to develop an enhancement incorporating these levels of firearm use. That would be a little bit less detailed. Without locking in the way that it gets done and allowing for some potential creativity, since the commission, actually has several levers that it can pull to ensure that sentences get increased, including increasing the severity level of the offense, increasing the duration of sentences, flipping it from presumptive probation to presumptive prison. Like there are multiple levers that we can actually pull within the guidelines. And if the commission had the flexibility to look at those different options and analyze the best way to do it, like that's been one of my discomforts all along, is are we locking them into something that maybe they could come up with a better option?
Can I ask a question about that too? Because I think in Nate's first proposal, it was sort of let's increase the statutory maximum 5 and 10 with directions to the guidelines to account for that. And then in the second proposal, it was more, it's going to be 12 months, it's going to be 12 months. Is it common for the legislature to draft a bill and tell the Guidelines Commission and do this exactly at the 12 months? Or do they normally say, we've made these changes, you all figure it out?
They go a couple of different ways. So, for instance, sometimes there'll just be a paragraph in the session law that tells us that we have to consider something and do it, and then come back, and then the way that it always works is we do that work, develop our proposal, submit it to the legislature in January. They have one session to say, it's good to go, or we're stopping it from happening, right? So that's one way that they do, and that's how they had us review child pornography. And we had like an open door on how to address child pornography offenses. Another way they do it is a more direct signal, like by increasing the statutory maximum for a sentence. If they doubled the stat max for a sentence, for instance, that's a clear signal to us that our sentence needs to be increased based on that, but they don't tell us how much. they usually just tell us they do that, and then we have to react and decide, okay, does that mean we move it up a level of severity, or what do we do there? And then like recently, we had some really interesting language in this last session where it was like 50%, the stat max is 50% higher or something like that. So it gave us like a proportionality kind of direction. So they can do that. And then sometimes they directly legislate, like when we first submitted the sex offender grid, that was a whole new concept. And, oh no, the drug grid's a better one. When we submitted the drug grid, they directly legislated that, certain offenses would be at this severity level, not this one. And that the stat max here, they gave some specific direction on how the grid had to look, because they didn't love it the way that it was, but they loved most of it, right? So they wanted, 2 offenses to move. So, they have a lot of ways that they can do it. And so we can also think about all those different approaches.
And if I could just jump in quick, I guess the reason, for all the reasons I think that Kelly outlined for why I think, all the reasons that Kelly outlined are the reasons that I would say that I would argue for, moving this to the guidelines, because the guideline is the guidelines commission is made up of experts that work with this stuff all the time and think about these things all the time. Basically, people like on this call, right? And but they have like a lot of time compared to the 2 more meetings that we have. And they also have the ability to make changes if they need to and tweak and adjust. Whereas the legislature, there has to be quite a bit of groundswell support for them to make big changes at least. And like I think the drug thing was or the drug example is a good one, where they were like, well, wait a minute, we don't really like this, and there were some groups that wanted to have some changes, and so it actually pushed the legislature to work on the process on a bill that came to some agreement. And I guess in terms of the work that we're doing, because a lot of these questions about things like ranking the possession, firearm possession things, and like possession of an accomplice and all those kinds of things, it seems like an output of this could be to say something to the effect of, these are the things that we think the legislature should change or do here. These are the things that we think the legislature should send to the Guidelines Commission and charge the Guidelines Commission with addressing. And then for some of those things, like the ranking of the whatnot, of the different gun possession or gun use and whatnot. I mean, those are things where I think we could take some where there's a little bit less gravity from our perspective. Because we, last time I think we spent a lot of time on talking about like ranking these tiers and doing all these things, which I think is important, but also we could. It's less of a final thing, and so we can say, look, there was majority support for this, but there was also support for that, and so this is something that we could that we encourage the guidelines to think really deeply about, and that and that way I think it it doesn't put so much pressure on us to try to get through all of these things, and because all of these things are kind of load bearing. And so these are very detailed oriented questions, I think, that we're going to be talking through. So but I did see 1-8 is, basically about, should we trust the legislature to or the Guidelines Commission to deal with some of these statutory maximums. And so that's where I think if we have that conversation first, then it changes the tenor or the complexion, I think, of the of these other questions about like removing or the nonviolent drug stuff, the gun possession ranking, all that kind of thing.
Mm-hmm.
But that all being said, what I do like about some of the legislation that you gave us some, an example of, Nate, is sort of the having the forward-looking repeal of the mandatory minimum, with the deadline tied to the commission coming back with how it's going to move there. I do think that would be really smart to draft that legislation and give them the ability to say, yeah, it is going to happen. And we're putting it into the future, and we're expecting the timelines to all line up.
And Jeremiah, I see your hand, but I'm just want to comment on what Vice Chair Mitchell said. I think what made the sort of the thing that made the drug offender grid happen in 2016 and the whole Drug Sentencing Reform Act was the idea that you just said it's going to happen. And I think it's helpful to have something like that, you know, but I also think it'd be problematic to recommend a repeal of 6911 without some kind of a replacement. I think that would be a lead balloon politically to just say, okay, we're getting rid of all these, you know, unless there's something specific. But I suppose I don't know.
Well, the
It's a super
specific-
interesting idea, but what,
Specific thing could be something like this is repealed. The direction to the commission is something along the lines of the commission shall develop a sentencing enhancement for gun use that incorporates these tiers of use and then the tiers that you drafted. And something like right along those lines. It's broad, so they can figure out how to incorporate it. But they have a deadline too, right? They're always the legislature gives the commission a deadline
For
when
sure.
they have to do work.
yeah. Jeremiah, go ahead.
Yeah, so I kind of threw my hand up on this just to kind of maybe get a little clarity, and I apologize. I know that last meeting I wasn't able to attend. But when we're talking about this, really I'm thinking, are we looking to add this into the 60911 chapter or section, or are we looking to, because as I read this, I'm thinking of like aiding the offender after a fact, or aid and abet, and is that a more appropriate place to place this style enhancement related to firearms? And if so, it's one of those things that I think it gets kind of touchy. At what point in time in the commission of a crime does an individual become aware the weapon is involved? And then what is their culpability then thereafter with their actions once that occurs? It's one of those things. If I'm me and my friend are going to go do whatever, they pull a gun and I don't know anything, but now I'm the driver of the car. I helped him get away. I don't make any means to cooperate with an investigation, that sort of stuff. When I'm here primarily as a witness to a crime at this point, but because it's my friend, I'm not going to partake in the investigation, or I'm aiding them. Did I know they had a gun? No. However, at some point I did discover or find out that they did. And then are my actions going to be held accountable into this based on what I do, knowing that?
Yeah. And that's kind of to the accomplice liability point, which I think that's an interesting point, that make it a little more complex. But what Rob is suggesting is maybe we shift gears at this point and look at decision point 1-8 and discuss the, given the fact that at our last meeting there was general agreement that it makes sense to grade the punishment to the severity of the offense and the criminal history score of the person who's committing the crime, two things that 6911 does not do, and also by the degree of the weapons involvement. So we agreed last time that, there's already a structure for offense severity and criminal history called the sentencing guidelines. So, it made sense to piggyback this onto the sentencing guidelines. And now what Rob is suggesting is maybe we should just kind of, in a way, just kind of pass this whole project off to the sentencing guidelines. And then that brings up the question, well, what are we asking the legislature to do then? Are we asking them to repeal 6911 or at least, the relevant subdivisions of 6911? I don't know how you'd repeal. You still have to do something with that offense list in subdivision 9 because it's used in other places, but
Can you, Nate or Kelly, refresh my memory about how the it worked with the drug sentencing changes? What initiated that?
Well, I don't know. It depends how far back you want to go, but
But what forced the legislature to act? What caused that to happen? I know it was the
Yeah.
guidelines recommendations, but
Yeah, I mean, I just have to say, just lest people think the commission's just routinely going around, kind of trying to force the legislature to do stuff. There was consensus for years that Minnesota's drug sentencing scheme was out of whack. I can't come up with a better word than out of whack. It just seemed like that's what everybody agreed, but nobody could quite agree on exactly the solution. And it was never quite this was never quite the right year to make that change. So, and there were task forces that were involved in, admiring the problem and so forth, but no real consensus ever came up. And then, the chair in 2015, Justice Dietzen, basically decided this is the year we're going to do something about it. And to some extent, the commission, Kelly said that the commission has more levers, and to some extent they do, but not as many levers necessarily as the legislature. Unless the legislature gives it levers, the commission generally. So, for example, the commission wasn't going to go looking at drug thresholds, and change, the grams in a drug threshold or that sort of thing. But the commission, based on the existing law, came up with a new drug offender grid that sort of organized drugs in a different way, and sent that to the legislature. And so the 2016 legislature then had sort of a ticking time bomb on their plate, because on August 1st, this was going to take effect unless the legislature by law provided otherwise, and the legislature did. So essentially, it was the commission putting the drug offender grid in their January 15th report that forced the legislature to get in the room, and we then became the bad guys, where everybody hated our drug offender grid, but what's a better option? And that's essentially what emerged, was the Drug Sentencing Reform Act, which was consensus based. It unanimously passed one of the houses and a strong majority in the other, and it restructured drug sentencing, changed a lot of the drug laws, the underlying offenses, new offenses were created, and that was the hand was forced by the commission in that case.
Yeah, so thanks for that. And this group can't tell the commission what to do, but we could recommend that the legislature pass a bill that tells the sentencing guidelines to do X, Y, and Z, right, with some clear guidelines. And I kind of like that idea, because it's sort of becomes a multi-step process where we give them, or we suggest to the legislature some, pretty clear parameters for the guidelines. And that might pass based on people like, there's some of these things that might need to change, knowing that they have a second bite at the apple, so to speak, because once the Sentencing Guidelines Commission does this, the legislature can say, no way, we're not going to do that, or we're going to change it. Yeah.
So, and that sounds like what Rob is saying. So I guess to Rob and Mark, would you envision then that there'd be, so let's just think about time. So this would be at the 2027 legislature directing this to the, fall 2027 Sentencing Guidelines Commission. How much time do you think they would give the commission to do that? Would it just be the fall, or would they give them a year and a half to kind of come up with a complete scheme? Because it does seem like that's a bigger ask of the commission than the current proposal, and right now we're just giving the commission basically 6 months, from the end of the legislative session to the following January.
I think that's a good question, Nate. Maybe we could hold off on that, and actually even kind of here's the thought I have: is we continue going through the process where we've started, And if there are things that this group has complete consensus on, we could recommend that to the legislature. But if there's parts of it where we're like, we're not sure what we should do with the tier system, or whatever, that could be something we could, use this approach for. I'm thinking of sort of a hybrid approach, but we get through where we're at on everything, and then this is a conversation about how we move it forward.
So, I mean, it does seem like this. I see Rob's point about if this is a direction we're going to go, it's really could be just a completely different direction, and could, in a way, sort of simplify the remaining work that's before us. So I'm asking Julie, do you think it makes sense to kind of jump to 1.8 and look at that question now? Okay.
So,
I mean, yeah.
Go ahead, Rob.
I just wanted to really respond really quickly about the reason, among the other reasons that I think that the guidelines the Guidelines Commission is a place for something like this, is the Guidelines Commission, when something is put in 60911 or some other statute, right, it's just kind of like, there's the words and that's it. And so it's interpreted in somewhat different ways and applied differently along different places. But the Guidelines Commission or the guidelines themselves always contain comments, right? And further explanation where necessary. And there's a lot of comments right now already about how to apply the mandatory minimums and whatnot. So I think it would be, this would, to Jeremiah's, example, this would, the Guidelines Commission could provide, guidance related to some like examples like Jeremiah provided, right? That then would, help, both the the court actors and the judge and whatnot to work through these things without, which is more than just a couple sentences in a statute, in a statute subdivision. And so, because you can provide some of the background, you can provide some, some examples of how to work through it. And so, and I wouldn't say it's necessarily kicking the can as much as it's saying like, we have this meeting and next meeting, and then that's it basically in terms of work. I mean, there's the last one, but like, so, I mean, it's just, we have a lot, there's a, we could spend a lot of time, on a lot of getting in the weeds on a lot of these things. And that's where I worry about that, but.
Can I add on to Rob's point real quick too?
What's that?
Can I add on to Rob's point real quick?
Sure.
And I think in addition to that, in addition to what Rob is saying about how the guidelines have all the comments to make it easier, putting it on the guidelines, we then also have someone reviewing a worksheet. And they're not always right, but I think that's sort of a healthy backstop versus, boy, I sure hope we got the statute right. Have we read all the case law to make sure we're doing it? We also then have someone else saying, yep, we've all done it right. It's been reviewed by the Guidelines Commission before it goes to the court. So.
Well, let's kind of officially move it over to 1-8 then, and have Julia move us through that. Okay, so we got an A and a B here, and it sounds like there's really a C, other, and there's always an other, but what yeah, so it's really a different approach altogether. And I think we've been having a pretty good discussion, but we've been just hearing from a limited number of voices. What do other folks think about I don't know, potentially repealing 60911 at a future date in 2028 or maybe even 2029, and kind of thinking of my retirement calendar here as we're discussing this, but giving some kind of directive to the commission to come up with a replacement punishment scheme for 60911 that considers the following factors, X, Y, Z, so forth.
Yeah, I mean, I guess I would
weigh in that that seems to me to make the most sense given like the I guess I guess honestly, I don't necessarily feel like I have the knowledge to make an intelligent uh decision on different tiers and so on and so forth. But I do feel like through the process of this group and being confronted with the evidence and having these discussions, kind of what's really been brought forward is I haven't seen a lot of compelling evidence for like keeping what we currently have. And so then my thought goes to, I guess I'm understanding correctly, like repealing it, but giving a group that has, even more of those that skills and knowledge and that task to be making those more specific decisions just seems like the smart approach in how I guess how I can weigh in on this. So yeah, that's I would be in favor of going in that direction.
Judge Harris.
Yeah, can I just ask a clarifying question about 1.8 when it says convert the increased statutory maximum penalty? Exactly what are we talking about there? Is that incorporating all the tiers and everything, or are we just?
Yeah, I mean, this was assuming, I mean, I think this question is sort of changing, right? Based on what Rob is saying. So my original vision was that there'd be this repeal of 60911 in effective August 1st, 2028. And then there'd be this replacement statute effective August 1st, 2028 that would create these different durational increases where basically a 10-year durational increase would equal 12 months. So if you committed a listed offense using a firearm, you'd go to prison for 12 months longer. And whether that's something, and just to repeat myself from last month, that just happened, right? The legislature just created a 10-year statutory maximum increase for any felony that's committed while impersonating a peace officer. And the Sentencing Guidelines Commission just created a 12-month durational increase now. So if you commit any felony now while impersonating a police officer, the duration on the sentencing grid is going to go up by 12 months. So that's sort of what we're talking about here. And Rob's asking us to maybe reframe this question to, should we just totally trust the Sentencing Guidelines Commission with the whole 60911 replacement project, basically? So the legislature would repeal, I guess, everything except subdivisions 1 and 9, because you still need that offense list for some things, but of 60911, and then you give the Sentencing Guidelines Commission until January 15th of 2028 or January 15th of 2029, depending on when you repealed 60911, to come up with essentially a replacement punishment scheme.
All right. Well, I mean, I thought from the outset anyway, the idea was to try to fold 60911 into the guidelines. And as speaking as someone who was a practitioner, I'm still in support of that. I think that whenever you've got to go from the sentencing guidelines to the statutes and back, that's where stuff gets missed and it gets complicated. I certainly am in favor of trying to give the Guidelines Commission or the legislature, a framework for that, but being mindful of the fact that we've got today and we've got a meeting next week that I know I'm not going to be able to attend. I do think we're running out of runway here. But I mean, this to me was always kind of and I thought there was a pretty broad consensus of that, is to try to take those statutory mandatory minimums, repeal that and incorporate it into the sentencing guidelines so the practitioners are looking in one place for it. So if we can accomplish that but still give some deference to the sentencing guidelines to work out the details of it, I would be in favor of that.
I just have a clarifying question, maybe a bit of a comment. So my understanding is that the sentencing guidelines wouldn't be able to create any mandatories. I don't think they could change dispositional status on anything, but maybe they could. But I think we need to
They
be clear
can.
that if they can, okay.
They
But
can.
they,
I mean,
but this there would be no opportunity to have any of these mandatories anymore with this process, right? So that's something that if we supported this would be, unless the legislature changed what the guidelines does.
yeah, it is true that every presumptive sentence of the Guidelines Commission is departable.
Yeah.
If substantial and compelling reasons are present and a judge can articulate those. Shane.
Yes, if I were to answer the 1-8 question, I'm somewhere between a B and C. And where the C would come in is depending on how specific. I probably fit that group of people that Nate was describing, that if the recommendation is just to repeal 60911 and have no replacement, that would just be a lead balloon. From what I've seen from the Sentencing Guideline Commission over the last several years, I don't trust that there's going to be a replacement punishment system. I would see it more as minimal at best and other things that detract from what the replacement punishment should be. Now, but Judge Harris's comment is one I do agree with, the idea that we should have a sentencing structure that more weds the guidelines, even if they're mandatories, because that's how the drug penalties work. Not the old mandatories, but the new ones with you have over 100 grams and there's 65 months. Those are all rooted in what the guidelines numbers are in locations. And that I think is a good idea. So the more the report, if it's broader on principles and kind of doesn't answer who should decide, that I'd be much more supportive of it, because I think we have generally broad support on a number of issues of concepts, but I think it's getting into the details. Example, that the crime of violence list in some way should be limited. The weeds are which ones.
Right.
So if we're recommending, change the crime of violence to better fit those we're seeking to punish, that makes sense to me.
Jeremiah.
Yeah, if I'm kind of hearing the way this is shaping out, and I think we all have some common ground on, yeah, maybe there are some things we could probably maybe kick to the sentencing guidelines, but we also should somewhat maintain some of the more severity in maybe that mandatory minimums. And if that were to look at, say it just gets added on to whatever sentencing guidelines are there versus, the mandatory 5, here it is. If we choose to look at something, depending on severity, it's going to be an additional 36 months if convicted of this crime with these factors or something along those lines. And correct me if I'm wrong, but I feel like that's what I'm starting to hear. And if that's the case, then maybe that question is, okay, is our next step to carve out which ones we're going to say, you know what, I think sentencing guidelines can handle kind of these ones, and we focus our efforts on the more severe ones and reforming the statute to those. Was just kind of my thought.
Yeah, I mean, that's an interesting approach too. I don't think that's what Rob was originally suggesting. Do you have a comment on that, Rob?
I guess what I'm saying is the details that I think both Shane and Jeremiah kind of pointed out are the things that those are going to be the hard parts that I think are going to be really difficult for us to come to like a meaningful resolution on. But I guess, I don't know. I mean, we already, I guess what I see the guidelines as already having lots of different enhancements already, whether it's, for this, that, or whatever. And so, I see this as basically an offshoot of that. And, yes, it would be appealable, but I mean, we already have evidence that hard mandatories aren't actually followed, 100% anyway. So it's not, but I guess I'm flexible. I mean, Judge Harris's point about the framework is kind of what I was is more what I was is generally what I was thinking was, we provide, when we're talking about specific numbers or we're talking about like how to describe ranking these different things in these different scenarios and things, those are things that I think that the guidelines should work out, right? I mean, I think we can say like there was broad support for 12 months or 2036 or whatever the numbers are, but then let them kind of settle on it. I guess I just go back to I think a lot of the legislature, I think everybody on this call thinks a lot more about these questions than the vast majority of the legislature. And I think that's also true for the Guidelines Commission. And so, the reason the Guidelines Commission was created in the first place was to kind of divorce it from, everyday politics, right? And, kind of keep it a little bit as arm's length and being more kind of pushed by empirical data and, the experience of people that work in these systems. And so, how that happens or what shape that takes, I'm more flexible on. I just don't. So that I guess it's, I don't know. I don't know if that provides any more guidance or insight into what I'm thinking, but I just think like I think there are things we can be prescriptive to the legislature, but I think that there are things that are some of these in the weeds things, some of these really, these details that I think that are better suited for the guidelines to kind of hammer out and decide. So
when I think about it, like I go back to that 5-tier chart that you created, Nate, on types of gun use.
Right.
And I could see that a recommendation that like I could see the legislature literally giving that to this commission and saying, develop an enhancement that takes into account these differing types of gun use, according to severity and all of that stuff, so that they have a clear charge. Like you have to develop an enhancement, and you need to be responsive to the fact that the type of use that a person engages in has different levels of dangerousness for the community, and needs to be accounted for in the structure that you develop. So, I mean, I could see us basically helping to draft the legislation that tells the commission to develop that enhancement with that in mind. And if there are other ideas that we've talked about that also should definitely be incorporated, we can do that. Like, and also, I think that 5 tiers already incorporates the fact that a person already wasn't supposed to possess a gun and then did. So like those factors those are big factors that make a difference. So that's kind of how I was seeing it, is like, this is the structure that we're saying needs to happen. The 60911 right now is a one size fits all for all of these situations. But if the legislation was like, build it into the guidelines, ensure that these different types of use are incorporated into the sentence, you can get more prescriptive if there's something else in here that, or some other idea that you want to make sure gets represented in the sentence. we can say that, and we can agree on that statement and incorporate that. But it gives a little bit more flexibility to the commission. So for instance, discharge with a person who shouldn't have had, it's a repeat offense, or they shouldn't have had a gun in the first place. We can make that a presumptive commit no matter where it falls, you know, on the grid, or whatever, you know, we can take, or the prohibited firearm use, we could maybe flip it to a presumptive commit, if it would have fallen into the probation zone. So we have a lot of options for what we can do that may actually end up being more effective than the structure that's here. Or may, you know, we just may realize later that there might have been another way to do it that would have been more responsive to the harm that was caused.
Well, I mean, this is sounding like potential consensus item. I don't know. I know that I guess I'm hearing Shane and Jeremiah maybe articulate. And maybe we need to get into the nitty gritty here, but I mean, it's so the nitty gritty I would see being a repeal of, I'm going to say 6911, but I don't mean the whole statute, but the mandatory minimum elements of 6911.
In the future.
At a future date, and I would assume it would either be August 1st, 2028 or August 1st, 2029. And then a direction to the commission to by January 1st of 2028 or 2029 to propose a replacement penalty scheme that, you know, appropriately considers the weapons involvement in committing violent crimes. I think you could just leave it at that, because the commission could even come up with their own list. They did. They came up with a list called severe violent crimes, 2013. I can't remember when that list was created, but basically, if you repeatedly commit a severe violent offense, then you get an additional penalty. And this was something the commission just did on its own initiative, based on crime victim input. So it can do something like that. It could create its own, you know, violent crime list. So you give the commission some kind of directive to you know, come up with a penalty enhancement scheme for using or in some cases possessing firearms or other dangerous weapons while committing violent crimes, and maybe give an explanation of why they're doing that. I think that's how I'm seeing this, you know, idea, how it would manifest itself on paper. Rob? And
I wonder
Shane,
if
Shane, your hand hasn't gone down. I don't know if your hand is up again or if it just hasn't gone down. Okay, thanks.
So I wonder, so hearing Shane's concerns about, you know, what the guidelines might or might, you know, like how that might turn out. I wonder if maybe, and we talked about triggers, right? Pun intended. No, we talked about sorry. We talked about like you know, kind of using the leverage of the legislature. You know, I wonder if saying, you know, recommending to the legislature, look, you know, here's a general framework that this task force came up with, you know, and talking about some of these things that we're talking about with rankings and, you know, and whatever. And that you have until, let's say, you know, the start, I would say the 2020, so I would say the 2029 session. So to give the guidelines actual time to do this, otherwise it's going to be everything they do for the next year and a half, or, you know, for 6 months or whatever. So give them a year and a half to develop it, right? In times for the next biennium or the next legislature, the 2029 legislature, and then present it, you know, or have it presented in the way that you usually do. And then it's up to the legislature. It's if the legislature chooses to, you know, to block it, they can block it. Otherwise, and if they do, then 60911 stays as it is, and, you know, life goes on. Or whatever the legislature plans to do. And that way it's not just a, like, we're going to repeal this or else. It's a, present us with something that you think is better. And then if we agree with you, or if we don't think your idea is really bad, then okay. Otherwise, we're just going to stick with the status quo.
Right. Yeah, and that's the whole idea of giving them till January 15th, because that's their normal deadline to propose things to the legislature that then the legislature has that's really integral to how the commission was designed. Its ideas always get submitted to the legislature, and the legislature has basically a full session to think about it.
But then make any repeal conditional on, replacement with, approved replacement by the legislature or whatever, or however you want to word it. But that way it doesn't just wholesale remove this thing without having something in place of it. And then it also kind of pushes the guidelines to, consider the legislature's appetite for the types of reforms and how it's going to replace whatever or what's currently there.
So you wouldn't repeal it. You'd have a conditional repeal. I don't even know if that's legal to have you can have statutes repealed on future events, but
I guess it would just be like part of whatever, like along with whatever the guidelines commission turns in January 15th in 2029 would include language for the revisor about repealing 60911. I mean, it would maybe wouldn't be like an explicit, mechanical trigger, but rather kind of like an understood kind of trigger guidance.
right. I mean, because if you had a future repeal of 60911 in 2029, it would be understood that the 2029 legislature could cancel that repeal if they hated whatever the commission came up with. Judge Harris.
Yeah, I mean, I guess what I was envisioning there is you give a date in the future for the repeal, and then in the same legislation, you say the Minnesota Sentencing Guidelines Commission shall, and then fill in the blank. So that gives a deadline for the commission, as well as making sure that there's going to be some sort of a substitute for whatever, framework from 60911 you're trying to incorporate into the guidelines.
Right.
Yeah, that's how I think it should work.
Yeah, I think so. Procedurally, how would you suggest we go from here?
I'm wondering if back to what Mark was saying, if it makes sense to go through the slides and just kind of get some taste on things, because if there is consensus, then some of this can be written in as examples, or I don't want to use the word guidance for the guidance team, but yeah, I mean, I don't know if we decide not to go into the weeds, I'm not sure. But I'm thinking that we might be able to get through them a little quicker based on this conversation. So that's one.
Yeah, I'm almost thinking we could, if we kind of come to consensus on this, I feel like we could move to the other ideas, honestly. I mean, I feel like here's what I would suggest is maybe I could write something up before next meeting, sort of like some language, incorporating bill language. I suspect the big haggle will be over, some of the big haggle will be over the directive to the commission and what's in that. But maybe we could do that at next week's meeting. And since, this is kind of a new idea, and I think to get maybe deep into the weeds is maybe unfair at this meeting. But it feels like that's something we could tackle next week, and maybe we move on to the, you know, the 624-712 list and the, you know, off ramp for felon in possession and the predatory offender registration issues. Does that make sense to folks? I mean, I don't know if we need to take a vote on it, but I feel like this is in a way kind of a relieving idea, because it does take a lot of the detailed work that we would have to do right now or else, and kind of not going to say punt, but, you know, give it to a body that doesn't have the same, well, I guess we could be giving them a deadline, but it's a pre-existing body. It's the only real criminal sentencing policy body that exists on a standing basis in the state of Minnesota. And this is well within their wheelhouse of sentencing policy. So I think they should be able to handle it. I will say that there's going to be a changing of the guard at the Sentencing Guidelines Commission next year. The new governor will be appointing new members. There will also be a staggered term system that'll be implemented. I'm not exactly sure how that'll work, but just so you know, it won't be exactly the same Sentencing Guidelines Commission. But I think this timeline would actually work well for that, because the new commission should be in place by mid-2027, which is when the law would probably get enacted. Mark?
John?
It's
fine. It's 10 months.
Is this?
Do we at least want to, before we move on though, I mean, I think Kelly had a good idea on telling the guidelines, consider these tiers.
Yeah.
Do we want to at least see if we have consensus on the tiers? Just because since we sort of have, I think, a good tier list now, but we could vote on it. I'd hate to spend an hour of next meeting going back and then redebating the tiers. Do we at least want to do that for whatever you'd be writing for the proposal, or do you just want to push it all to next meeting?
No, actually that does make sense, because I think one of the reasons we were having trouble with the tiers is that it all got down to the specifics on how you were going to implement it. But if we're not going to talk about the specifics, but just that these are the tiers and this is the sequence of tiers, yeah, maybe that does make sense to talk about it.
Jeremiah has his hand.
Jeremiah.
Yeah, actually, that was kind of what I was looking to see before we kind of made a conclusion, or excuse me, any sort of vote or anything on this. If we were going to kind of relook at those and identify, you know, I think we brought up some really good points in regards to, if we give this all the sentencing guidelines, what that looks like, how that gets interpreted. You know, just looking at some of the kind of ones we've already thrown in there, it looks like we've substantially reduced any sentencing time on some of these. In a sense, we're not having a 5-year mandatory anywhere. So if we look at, you know, the actual prison time in 2/3, the reduction is getting a lot lower. So some of those things are, you know, I would just like to have some direction to make sure that, you know, while we can look at those, there are certain things that we really need to, I think, still hold people accountable and, you know, really articulate a difference of, you know, robbing somebody through force and taking a purse and whatever, and they get skunned up, versus pointing a gun in their face, you know. And if we're looking at the difference is only going to be, you know, 14 months, is that really reasonable on some of those? So I guess what I'm getting at is, if we go over these tables and we're talking about these things, I think that's, you know, for me to support a lot of that is I want to have some clarity through the legislature, and my recommendation on what kind of we decide as a group should be appropriate in that table to send forward to commissioner or the sentencing guidelines.
So you would like to send some numbers in there as well, not just the tiers?
Yeah, I think, and again, then this kind of, I'm just kind of spitballing as we're all talking about these things. Everyone's bringing up some really great points. You know, if we look again where, you know, I was kind of talking about, maybe we maintain mandatory minimums in the statute in there. Maybe we can not do necessarily maintain a statutory minimum, but maybe it gets pushed to where we are more, you know, we're adding on time on sentencing. on some of these offenses, just to kind of see what our group looks like to figure out if that's a consensus on how we do it.
What I was thinking is I really like Julie's suggestion earlier, like this framework that was developed for us to kind of work through that does have durational increases could be included in the report as an example. Like it wouldn't tie the commission to the 6 months or 12 months, but as an example of what we mean by the sentence has to include an enhancement for each of these factors, this for the weapons involvement in some way. Here's an example of one way that this task force thought about it, but it could, but the commission could consider other things such as, ranking the offense at a higher severity level, or if this weapons involvement, or requiring a presumptive prison sentence for certain of these actions, that sort of thing. So that's, I think there's nothing wrong with having the numbers like this in the report, but I think that maybe more as an example than as like, this is exactly what it has to be at this stage. Would that work for you, Jeremiah?
Again, I think for some of these, I would agree to that there are some in there, but I just, as far as like accountability, and we talk about public safety, and sometimes it's not preventative, but it is. Hey, like it is the accountability in us, and we have victims attached to these crimes, and the egregiousness of those. I think, and that's kind of what I think Shane was talking about in regards to having some of those still in there and defined, so that if some judge wants to, overturn something, or they want to, not overturn something, they want to do a gross departure, and the attorneys aren't on agreement on that there is still that meaningful point where society can end up getting that, and the victim can have some of that feeling of a sentence that occurred.
The other thing I was also thinking about, there's two ways we could do this. Like there might be some, I hear what you're saying, Jeremiah, that there might be some things here where we still want a mandatory minimum. And, like I could see tier 5 being a place where maybe a mandatory minimum is still appropriate, but maybe it's drafted differently than it is now, right? So one option is, if there's something that everybody here agrees should remain a mandatory minimum, we say that. The other option is the direction of the commission is also to recommend whether there is a level of weapons use that requires a mandatory minimum, and recommend to the legislature that they incorporate that. So that kicks it down the road a little bit, having the commission come back with that recommendation, and whether there should remain to be mandatory minimums for any weapons involvement. But that's an option too.
Judge Harris?
Yeah, I agree with Jeremiah that when you're talking about an aggravated robbery, there's a wide spectrum of conduct on that, and the use of a firearm makes it different. And so one thing that I was going to point out is when we talk about potentially changing the severity level, that can move you from the shaded to the unshaded portion of the grid. And from a judge's standpoint, you're looking at completely different factors for a durational departure versus a dispositional departure. So you could have an offense that's less serious than usual, but not necessarily have the offender-based characteristics that you would need to be the difference between prison and probation. So, again, that's where the devil's in the details, but at least in my experience, the durational departures were less controversial usually than that decision of prison versus probation. That seemed to me to be when there was a real fight anyway between the parties. And so I like the idea of sentence enhancements because once you figure out if you're a presumptive stay or a presumptive commit, then there's some wiggle room for, like when we were talking about the accomplice liability for, if you don't build knowledge as an element into the offense, if the person didn't know that a gun was going to be used, then maybe that's a justification to say the offense was less serious than usual, and you could move that durational sentence down a little bit. But I think where we're probably going to have the most debate on this grid anyway is where is it a mandatory and where is it a hard mandatory for the prison versus probation connection. And I think that I don't know if we're going to get to consensus on that, but I do think that that's when we're putting a grid like this together for the Sentencing Guidelines Commission. I think that's where the rubber is going to meet the road for me.
But I remember Mark Osler was big on discharge. I think that was his red line. I suppose there could be a situation where you could include somewhere in statute, just keep the idea that if the commission's, whatever the sentencing guidelines say about discharge, for example, I'm just throwing this out there, that would be a hard mandatory, basically, that would not be waivable.
And I would not have much problem with that, because I think, frankly, if a gun's actually fired, you're going to have a much harder time getting any kind of a departure argument to have traction anyway. Where we draw that line is, great minds can disagree on it, but that one for me would not be all that hard to swallow.
Yeah.
I would immediately push back on that, because I think what you're saying there, Judge Harris, is it'd be a harder time for you to find a departure. And I think you could still find the one case, because I think as a judge, you probably always had the one case. And I know that was sort of a drum I was beating last time of, if you say discharge, hard mandatory, not waivable, in any imperfect self-defense where you might want to grant that departure, now you can't. If you've discharged twice, you might get me, because again, as I've said before, I don't think anyone is that unlucky twice in a row. But the first discharge being a hard mandatory is where I sort of push back, because I think even if you were a judge and you had that case, you might go, God, I really wish I could depart for this guy.
There's always the exception that proves the rule. I don't think, and I've said that before.
Yeah, and that's why I always push back on a non-waivable mandatory minimum, is there's always going to be a case. But also, a little bit, are we getting ahead of where the mandatories kick in versus where they don't, without actually, do we agree with these tiers? I think that maybe has to be the first question we answer before we get into it.
Yeah. So do folks agree with the idea of putting tiers 1 through 5? This isn't verbatim how it was in the proposal, but basically, so the first one would be, there'd be a weapon. That'd be a firearm, right? So it'd be either a firearm on the person while committing a violent crime, let's say, or the use of another dangerous weapon. I think that was tier 1, if I recall correctly. I'd have to look at what I had written. Jeremiah and Robert, you had comments?
Yeah, I just wanted to clarify, when we're talking about like tier 3 here, plus 12 months, firearm used, and someone, and I think a couple times aggravated robbery was mentioned, right? So like in reality, wouldn't this just be the existing, so first degree aggravated robbery guidelines with 0 criminal history points is 48 months, right? So this would be 48 months plus 12 months, so that'd be 60 months, which would be the mandatory minimum that exists right now.
Well, I think it'd be something on top of that. So you can commit first degree aggravated robbery by harming somebody while you're taking something from them, or was it using physical force? No, that's robbery. So harming, causing bodily harm, or having something that looks like a firearm or actually having a firearm. And this would basically enhance it if you actually use the firearm as opposed to the other two. You know, so if you had a rubber gun or if you had, well, I think
Right,
if
but
you,
what I'm saying is if you use it, you know, if you used it, right, which brandish it or whatever, that's 12 months on top of the guideline sentence of 48 months, right?
yeah,
And then if you're a person who wasn't supposed to have the gun in the first place because you're prohibited, then it would be 24 months on top of the. So, if I remember correctly, part of the reason for the tacking these numbers on was because there were a bunch of these cases where it was already a severity level 9 or 8 or something like that, and so with 3 criminal history points. And so the 5-year mandatory minimum ended up being kind of a moot thing anyway, because it's just served concurrently.
true. Yeah, let me just see what I had for tiers.
You tier 0 is firearm possessed off person or not with immediate.
Well, shoot, I'm not in the meeting here. Kelly, do you want to lead the meeting while I'm looking this up? It was, it's a Word document that it's called.
So we're just trying to pull up the decision points, the way they were originally drafted. Or the tiers of weapons use, the way they were originally drafted. Just give us a sec.
I always have problems with PDFs.
So it's right there in the middle.
Does that look right?
Is this the same kind of tier system that was put into that PowerPoint that was sent out here in the last email?
I think
Yes.
Revised it a little bit. I simplified it.
Do you want to look at the screen?
It's looking pretty close. Yeah, that's right.
Okay, so if everyone could look at the middle of the screen there, decision point 1.5, these are the tiers that we discussed for weapons involvement. So it's actually 6 tiers because there's a 0.
No, but the idea of tier 0 is that wouldn't be listed. That's not. There wouldn't be a directive for the commission to enhance offenses based on possession of a firearm in a gun safe or somewhere where it's out of reach and really not involved in the crime.
Okay, so then I'm just gonna actually like talk through them. So tier one, then use of a dangerous weapon other than a firearm or firearm possessed on the person within immediate reach or within the immediate reach of the person.
Yeah, while committing a violent crime. So these are all like while committing one of these violent crimes.
Okay, so basically we still have the list of crimes that like 60911 has, or some list of crimes.
I would suggest kind of leaving that up to the commission because I wouldn't say that list is perfect, and I would say the commission may have some ideas on improving that list, or they, maybe they don't even need a list. Maybe we just do what they did with the police officers and say any felony you commit while impersonating a police officer, the penalty goes up. It's like, I don't know. I mean,
okay, so it's a separate question.
It's
We'll just divide that out for
Sure,
right now.
sure.
But so while committing some crimes it will identify in the future. Tier two, the firearm is possessed on the person or within immediate reach, and the person has already been prohibited from possessing a firearm due to prior qualifying conviction or adjudication. Tier three, the firearm is used, so that's the brandishing, displaying, threatening during the offense. Tier four, the firearm is used during the offense and the person is prohibited from having that gun in the first place or that firearm in the first place due to a prior qualifying conviction. And then tier five is the firearm is actually discharged or repeat firearm enhanced offense following prior oh, you're gonna have to tell me what that one means.
Yeah. So yeah, I mean, I guess this would just be where you had done this before. So it's basically you'd done tier four before. Or I should say tier three.
So you've used the firearm before.
Tier three or tier four before, and whatever that prior offense where you had used, so you had used a firearm to commit a crime of violence, and that prior offense still hasn't decayed from your sentence. So it's recent enough that it's still relevant for sentencing.
Okay, so tier five is it could be your first time using a firearm, but you've discharged it, you've actually fired the gun.
That's correct.
Or it's a repeat offense with a firearm and it's and the prior offense has not yet decayed.
Right.
Okay.
Would that include a tier zero offense?
No, it would have to be use. So it'd have to be a prior use.
Okay.
So it'd be prior tier three or tier four.
Okay.
So if you do a tier three or tier four the second time, then it's a tier five. Right, and that just seems to be sort of consistent with what I've seen people viscerally feel like, boy, if you did that before and you're doing it again, you should really get hammered this time. So that's why it's built in there.
So the first question really is, how do people feel about these tiers, and does this capture the sort of range of weapons use that we want to think about when enhancing a sentence for an individual?
One thing that's catching me up a little bit is the tier two and tier four, where it's based on the prior conviction or adjudication prohibition,
The prior.
and what those prohibitions currently are. But that's a separate conversation. Yeah, I don't like them being that high if it might be a prohibition based on a 5th-degree drug offense.
Well, and that's a conversation we're going to have also.
Yeah. I just wanted to kind of side note that.
Yeah.
Other feedback on the tiers? Are we missing anything? Do you sort of generally agree with the progression?
Just one quick clarification that I'm trying to kind of conceptualize is the firearm off person. We talk about, locked storage, that sort of stuff. Are we talking a glove box in a vehicle? Are we talking, if it's the firearm is found, 30 minutes after a guy fled and dropped the gun, and now it's technically off person, a search warrant at a house where it went from being in someone's room where it shouldn't have been. And because of the way police practices are now, they had time to secure it into the storage safe. And they shouldn't have been having access to it. If we found it, in the, hidden in the house somewhere, so I would just, for me, I think we'd have to try to figure out what off person means when it comes into possession, and if they're prohibited people in possession and what that looks like.
Sure, great questions. Well, I found two cases since the 2016 law passed involving drugs, right? So that's where this term is currently used, possessed on their person or in immediate reach. And they both had to do with cars. And it's pretty clear that a glove box is considered in immediate reach, and that it even applies to a locked glove box. That was the case that went up on appeal. The glove box was locked, but the key ring that the driver was the defendant, that the key ring that was in the ignition had a key to the locked glove box, and the appellate court said, yeah, that's in immediate reach. So that's good enough for immediate reach. There was also, I can't quite picture exactly how this car was set up, but there was something about a console where you had to flip up something, and then you had to flip up something else, and then lo and behold, there's the gun. And that was in immediate reach, the center console. So those things would be in immediate reach, but otherwise, yeah, if you're possessing, well, right now, controlled substance fifth degree possession is a crime of violence, and this is where we see it a lot. Where somebody's possessing controlled substances and has a gun. Well, if assuming that fifth degree stays on the list, if somebody possesses controlled substances, but the gun is out of reach, say it's in the closet or it's in the gun safe or somewhere else where it's not connected with the crime itself, then no, the mandatory minimum would not apply. But if it were, in immediate reach, if it were in the nightstand, say, and somebody were sitting on the bed, that would be in immediate reach. So then it would apply. So it'd be a fact-bound basis. And if it was, it would be really up to the investigators to prove that, well, maybe the gun's over here now, but at the time of the crime, we know that the gun was in immediate reach. And that would be just like any other fact to have to prove at trial.
That's what I was going to say. It's just it's post-trial. People toss guns and can still get convicted.
Sure,
So-
exactly. And people toss drugs and still get convicted.
Yeah.
It's just a matter of proving it. Amber.
Yes, you had offhandedly said maybe any felony. But we're talking about the list in,
We have been talking about the
69.
list.
okay. I
But-
just,
but-
because it could get I wouldn't support if it were any felony, because there's a number of felony offenses, like even CVO, and they find a handgun in the, glove compartment. I don't know.
No, I hear that. And I guess where I'm coming from with that is I think we should, so we're kind of right now conceptually, at least what I'm doing right now is in my mind, I'm conceptually drafting like what the legislature's directive to the commission is going to be. And it's going to include this tier list, and then it's going to be while committing something. And I feel like we should give the commission some flexibility to not necessarily be bound by the exact list. There might be crimes that should be added to it. There might be crimes that should be taken away. I've got that picture, that memo where there are lots of, my suggestion would just be to say violent crimes and then let the commission figure out what that means. And, but members of the task force might have a different perspective, and this is the first time we've talked about it. So,
And then I think the only other thing that I had pushback on immediate reach again was if it wasn't used and it's legally possessed, I don't know if that should be an enhancement for someone.
mhm.
And I think like on the grid we were looking at previously, where it says firearm off person at a 0 tier and then fire weapon on person.
Yeah.
As a 1, I guess I took that as actually on the person, but
Yeah.
that was my only other comment. And I think there's a distinction between a felon, someone who's prohibited from possessing a firearm and having a firearm within their reach, and someone who doesn't have that prohibition. That's my only comments on that.
I guess, Amber, I would come back to the crime of violence or the violent crime definition there and say, to me, it depends on what the crimes are. Because I feel like if you're committing 5th-degree possession with a gun, I kind of get behind your Second Amendment argument there. But if it's really a violent crime, like if you're committing a violent crime and you're bringing a gun along, I feel like you're just increasing the whole point of this, right, is to increase public safety. And I feel like you're really you're jeopardizing public safety by bringing a gun to a violent crime. I mean, if we could, if people who would commit violent crimes didn't bring guns, we'd all be better off. Because things just go south when guns are there. Does that make sense to you?
It does. I guess I'm thinking like a 2nd-degree assault bar fight. Maybe pick up a bottle and hit somebody with it while you're actually carrying at the same time. I don't know that, and I apologize, my camera's not working, but I can see instances where someone could legally be carrying and not use it, but still commit a violent crime and have maybe an imperfect self-defense, but get bit with that enhancement. Although if these are something that can be departed from, then perhaps, that can be addressed at the trial court level with the parties as to whether or not this enhancement or, is appropriate under the circumstances, and there could be a durational departure or something like that that could help alleviate it.
Yeah, I mean, I think right now all we're trying to do is figure out the severity of progression of weapons involvement. And so even with the concerns that you're raising, Amber, I am hearing you talk about having a firearm in the person without just being a much lower, potentially lower severity level of weapons involvement than the other one. So it sounds like even with your concerns, you'd put it at tier 1 for the first timer, and probably tier 2 for someone who's not supposed to be possessing firearms.
Yes, I do agree with the overall ranking of it. I think I'm just getting into the weeds on some of the scenarios in which it might apply, but I do agree with the tiers that are there and the general conduct that would be encompassed by each of the tiers.
So I'm hearing, I think so far, I'm hearing that there's general agreement with the progression of seriousness that's represented on this table. I'm hearing questions about things like what does immediate reach mean and that sort of thing, but there is a robust case law already that addresses that concern. So I think, and we could call that out in the report too, just a reminder that those are terms of art in criminal law that are defined in case law. So we wouldn't be changing anything about that. And again, those proof that's what the proof elements at the time of trial or plea agreement would take into consideration. So I think that by using those terms, we're fitting into the existing framework of the law. So I think, do you want to have a vote, or you just want to incorporate this into a proposal that you're going to have us vote on next time?
Well, I mean, if maybe, let's see, who's not going to be here?
Judge Harris.
Well, I feel like, yeah, Judge, I feel like we can't really ask you in fairness to vote on a concept. I think we have to have it in black and white. So hopefully you'll be here at the August meeting, Judge, to you know, either ratify the July vote or vote against the July vote. Obviously, your choice, but I think I just don't think it's fair to you to ask you to. I just don't think it's honest to classify any votes today as being the position of Member Harris. You know, because you didn't really get a chance to see anything in black and white. So
I don't have any problem stating here that just conceptually, I do agree that that list of tiers goes from least severe to most severe.
Okay.
And I'm mindful of the fact that you're going to try to put something together in writing, and there's a holiday weekend starting tomorrow, and I'm leaving on Wednesday.
Sure.
But
Right.
if I get a chance to look at anything, I can provide written comments, or I can address it in August. I am, God willing, I will be here for the August meeting.
Okay. I mean, I think the only other thing really to address then is the list. What do we want to do with the subdivision 9 list? In the direction to the, I mean, there's going to be some technical things we need to do with the subdivision 9 list just because it is cross-referenced in multiple other statutes. But from a substantive point of view, though, I'm curious, what direction do we want to give to the commission? Do we want to reference the subdivision 9 list? Do we want to just say, you know, in connection with a violent crime, and let the commission kind of figure that out? What are people's thoughts there? And I will say we didn't really get into the elements of the subdivision 9 list, but I would really, I think there's some work to do even in the criminal sexual conduct arena. That is not, it's frankly irrational in some of the decisions, that some of the offenses that are not on the 6-11 subdivision 9 list, and some of the offenses that are, some of them are clearly more violent that are excluded from the list, versus some that are. So I think I think it's appropriate to give the commission some leeway on the list to exclude. So I guess my suggestion would just be to say violent crimes and leave it up to the commission.
I agree with that. I think it would take a long time for us to agree on them.
Right.
And you know, asking the legislature to do it is another, you know, will be difficult too, but having the Sentencing Guidelines Commission makes sense.
Amber?
I would agree to that, but I think I would like to include if we have a consensus on the 152 stuff, that would be at least a decent portion of it would be removed, and that, but or else I would otherwise agree to that.
Yeah, it is interesting. And I mentioned that list is cross-referenced in other places, and in at least one of those places where it's cross-referenced, and I think this may be true, the 624-712 list too. It says except for chapter 152 offenses. So they are already excluded in other places where this list is used. So the suggestion then is to is that something that would go in our report, or something that should go in the legislative directive to the commission? Amber, what were you thinking?
I was thinking in the directive to the commission. If
So,
if they're going to be, if we're also, they're also, I guess, would be directed to come up with the list, right? So specifically,
If
yeah,
I
I would say the directive.
Judge Harris?
My recollection, and I don't want to speak for Shane or any of the other members, is there was fairly broad consensus that we needed to eliminate at least some of the 152 offenses from that list. Whether we go with option A or option E or, something else, I think there was fairly broad support anyway that we don't need low-level drug crimes, including crime of violence. Whether we keep the first and second degrees is a, tougher question, I think.
I mean, I think I can safely say that there would be unanimity in saying the following sentence. Fifth degree controlled substance possession is not a crime of violence. So, and maybe that could just be, a clause written in the directive is that fifth degree controlled substance possession. And maybe it should say, for example, is not, or offenses such as fifth degree controlled substance possession are not crimes of violence. Because I don't think anybody thinks fifth degree possession is a crime of violence. Would that work for folks just to have sort of some non-limiting language like that? Offenses such as fifth degree controlled substance possession are not crimes of violence.
I think so. And I mean, we have a couple of other recommendations where we're looking at other lists today too. And
Right.
so maybe we can sort of think about, as we go through those, think about whether the things we're pulling out of there are the things we'd want to also pull out of this list.
Okay. Well, maybe I'm missing something, but I feel like we've kind of made some progress here with issue 1. And I mean, we haven't taken a vote, but we can do that at the next meeting when we see it in black and white. But I feel like we're getting pretty close to a agreement on this. I guess we'll find out how close at the next meeting. I appreciate everybody, the ideas that were brought. And now before we move on to the others, I know it's noon, so we're halfway through our time. Are people needing a lunch break? Did people brown bag it? Are they, do you want to just keep rolling on? What are folks thinking about taking a break at this point? I think it'd probably be a good idea to take a little break.
At least like 5 or 10 minutes, maybe.
Yeah. Okay. Let's see. I've got 12 on the nose, so let's be back at exactly 12:11. So you have a full 10 minutes. All right. Is there any place that's that close? All right. Well, we are back in business. It's 12:11, and which is exactly how long it takes to get to 7-Eleven and back from here. So, Julie, you want to go ahead and lead us
Sure.
to the next idea?
Okay, so we are on idea 2, looking at firearm possession. This is talking the after crime of violence.
Oh, right. Whether or not that's just whether a person who's committed a felony of crime of violence can possess a firearm in the future. Okay.
Yes.
Got it.
So I think I was flashing this earlier as we were talking about the 152 offenses, but here is a summary of what 2-1 is. If you go to page 8 of your handout that accompanies this, it does have the list of the certain offenses, which I've heard that we're not going to necessarily fine tune or offer to fine tune. Is that correct? We're not going to be looking at the offenses, but we are going to be talking about the drug, the fifth degree drug possession as one of the things that this group has decided that we don't feel should be on the list. But I'm just making sure that I don't need to pull the list up.
No, it's really just yeah, and just as a reminder, it's not just convictions that result in the lifetime ban right now. It's also juvenile adjudication. So anybody who's either been convicted of any crime on this list is currently banned for life from possessing a firearm. And this list is called the crime of violence list. So these are called crimes of violence, and for the most part, the offenses do appear to be violent. But the one that's always stuck out to me and to many others is including all Chapter 152 offenses. Chapter 152 offenses are drug offenses. Includes drug sale, drug possession, and most drugs, if possessed, are felonies. So to be any felony Chapter 152 offense. So the question is, can we narrow that down? There seems to be some consensus that at least fifth degree possession is not a crime of violence and could be taken off the list without any harm to public safety. And the question is, what other offenses, what other Chapter 152 offenses can be taken off the list? Do you want me to kind of walk through these different categories? Okay, so the first one is exclude all. That was a bipartisan bill that I think we saw in the last session to just basically strike Chapter 152 from the list. Then there are some Chapter 152 offenses that involve possession of a firearm, and this is where we see that language on their person or in immediate reach. So if there are certain first and second degree controlled substance crimes where the crime is more, I guess you could say the drug threshold is lower if the person possesses or sells drugs while they're possessing a firearm on their person or in immediate reach. And arguably those are the only crimes that even have a whiff of an element of violence. So that would be one approach. The third approach would just be to list this serious drug crimes. Is this I think this is what we, I think this was kind of loosely based on, so in Chapter 152.18, Chapter 152.18 provides a stay of adjudication process for drug offenses. And there are some offenses that are automatically eligible for stays of adjudication, at least for the first time. And this is based on those. So all sales are excluded. Importation and meth manufacturing offenses are excluded. But third degree possession, fourth degree possession, fifth degree possession would be taken off the list, and first and second degree would be kept on the list. So first and second degree would be on the list. Third, fourth, and fifth sale would be on the list. Importation would be on the list. That's actually a very serious crime in terms of its statutory maximum and the guidelines penalty. It's also very rare. And meth manufacturing offenses. Meth manufacturing offenses are less common now, but they used to be more common. There's a first degree meth manufacturing. There are also meth manufacturing offenses involving possessing precursors with intent to manufacture meth. Category D would be including doing it by the statutory maximum penalty of 15 years or more, plus children and vulnerable adult exposure to meth or fentanyl. This is the approach that's taken in 609-1095 subdivision, I want to say 2. The 609-1095 does it 2 different ways. One of them does it this way, and then the other one does it where under E, so it'd be only first and second degree drug crimes, and specified those children, vulnerable adult offenses. So those are two different ways of doing it. If you're going to model it after an existing offense, and then there's many different ways to do it, and I'd be really curious to hear from particularly those in the field on which crimes they consider to be inherently violent. Which crimes actually belong on the crime of violence and which do not. And then finally, it'd be retain current law. So Jeremiah, you got a question or a comment?
Yeah, I was just kind of looking at that. I guess my feeling is if we're going to go through and say, hey, we're going to exclude these, I almost feel as though, on the other hand, to be fair into what we're sending, we should also send, we're definitely including these. And maybe we can send a list of, we couldn't find the middle ground in some of these, just to kind of signal what we feel is really important as a group, and maybe kind of saying the ideas between us maybe didn't match up on some of these other, and send those to the commission for a little bit more of fine tuning.
Well, to be clear, I think for the rest of the time, we're kind of done talking about the commission and sort of their 60911 replacement. This is just a recommendation to the legislature to change the law. So this really wouldn't involve the Sentencing Guidelines Commission. And the way I pictured it, these would all be recommended to go into effect in 2027, as opposed to those other ones that are going to go into effect in, I guess now, 2029. This would just be, the law is wrong, the law should change. It's kind of the recommendation. And the reason why it's within our scope is because this offense is one of the most common mandatory minimums. Is violating.
Oh, that's
yeah.
Yep, my fault then. I apologize. I thought we were kind of still talking about the crimes of violence and what kind of got you into prior crimes of violence as we went and talking about the table.
Well, it is confusing because the 60911 list is in some ways similar to this list, but this is the list in chapter 624, where if you get a conviction under current law, you can't possess a gun or ammunition for the rest of your life. And if you do, you'll get a 5-year mandatory minimum. So, and I'd be curious from you or Nick or Ken, actually really be curious to hear what Ken has to say. Because Ken, I think this is kind of your line of work, isn't it? Sort of the intersection of drugs and violence. And I'd be really curious to hear what you have to say as far as what drug crimes are categorically violent. Not to put you on the spot, but
oh, that's fine. It is, and in my constituency are the drug task forces across the state, and I mean, even though we call them low-level drug crimes, like we see how many murders are involving marijuana or low-level drug cases that they turn into robberies. But I hate to minimize what a low-level drug crime is, but and I do agree that degree possession is not something that should be on the crime of violence list. But from the people that I represent in my position, that's as far as I'm thinking of going right now. But I do think that we need to include all the serious drug crimes, the first, second degree felony sales, importation, at a minimum.
Okay, so what about like third, fourth degree possession? Because those are missing on several of these lists. I'm thinking of I think C and E it's missing from. So would you be kind of in the category C camp where so you'd include first and second degree sale and possession, and then third, fourth, and fifth sale?
Yes, I did take a harder look at those statutes. And why are they not on here? Did we just forget them?
The actual statute numbers?
No, I mean the third, fourth degree.
So they are on the, so under C where it says felony sales. So that includes third, fourth, and fifth degree sale, but it excludes third, fourth, and fifth degree possession.
Okay, we just didn't list them.
Yeah, so this is, yes. So I mean, you can do it. You can either say what you're excluding or what you're including. This is just saying what you're including. So this would exclude felony possession offenses other than first and second degree. And that's probably even more of a confusing way to say it.
D would include fourth degree because it's the statutory max of 15 years.
Right.
Or does it have to be more than 15? Sorry.
No, 15 or more.
Okay.
So
then
yeah,
D is it.
D does include fifth. D does include fourth degree possession and third degree possession.
So if anybody's curious, for third degree possession, that's up to 10 grams of cocaine. So below 10 grams of cocaine, it becomes second at that point. 6 grams of heroin, up to 6 grams of heroin, just to give an idea of what we're talking about there for the possession at third degree.
Judge Harris? Oh, I think Jeremiah had his hand up first. Sorry, Judge. Judge Harris? I'm sorry, Jeremiah Carlson?
No, it's all good. I think I left my hand up. My apologies.
Okay. Judge?
I don't have the statute open in front of me, but third degree also has the enhancements for like school zones and public parks and things like that, which I'm not sure if we're getting that granular on this or not. You know, there's the quantity and then there's also the location, if I remember correctly.
I know that's true of fourth degree. It's probably true. I don't have these memorized anymore, but
No, third degree does have the park zones because that's where we're still charging residue in park zone.
okay. Amber?
Yeah, well, I was just gonna add with the C with a serious drug offense, that's the one that mirrors the 15218 statute, right? It looks like it does.
It's
for the most part.
close. Yeah. They didn't really update everything.
So, I mean, I think the other thing I was thinking of is the automatic expungement essentially mirrors that too, with the exception of third degree drug is not an automatic with a 15218, but fourth and fifth are. And, you know, I think relevant to this conversation is if the legislature's already deemed fourth and fifth degree possession automatically expunged if you get a 15218, I guess it makes sense that your gun rights shouldn't be affected by that either.
So I did not look at the expungement statute, Amber. I appreciate you bringing that up. So what offenses are automatically expunged? Is it just 15218s?
If they successfully complete the 15218, it's for violations of possession of fourth degree, fifth degree, and other controlled substance, the 152.027.
Wouldn't the expungement already allow them to then petition to restore their rights for firearms then under the court?
Not necessarily. I'm not.
Well,
an expert.
anybody can petition to have their rights restored.
Yeah.
Yes, it's just those are automatically expunged. At least the court record is under that statute.
It does not pardon you though, so I think you're still legally convicted and you still legally cannot possess a firearm. Well, I guess it depends what we're talking about. If the person got a 152.18, they never got a conviction. But if you get a conviction, you are, I don't think it matters whether you're expunged. It could be wrong. Rob, do you know?
Under clean slate 152.025, fifth degree controlled substance and sale of simulated controlled substance are both subject to clean slate. Even conviction or 152.18 or whatever. I mean, I think that's a question. This has come up, not exactly in this specific instance, but it's come up in driving, other like driving related clean slate things that, you know, can be aggravated or you know, affect insurance and things like that, and DVS and all that. I don't know the clear answer though, on whether that would affect your ability to possess a gun.
I know the sentencing guidelines, it doesn't matter if an offense has been expunged, it's still on your record. It's, I mean,
The last sentence of the statute says or subdivision 1C is the discharge or dismissal shall not be deemed a conviction for purposes of disqualifications or disabilities imposed by law upon conviction of a crime or for any other purpose.
for 152.18.
Yeah.
Yeah, I think the question, I think Rob was saying though, even if you're convicted, it's subject to a clean slate, true or not?
So clean slate says in 609A.015 section subdivision 3,
Right.
it says felony offenses. So it's basically the same list that's eligible for regular petition-based expungement, except for go down further. So it's subdivision 3. It's just above subdivision 4, paragraph D. I'm sorry. Right there. Right. Oh. Right there. Paragraph 4. Any felony offense listed in 609A.02, which is the petition-based expungement, except for third degree possession, or I guess possession of controlled substance in the fourth degree. But there's a specific waiting time. So if you look at below that, in paragraph C4, if the offense has a felony violation of section 152.025, then it's a shorter waiting period when it's eligible for clean slate, but it doesn't. I guess I haven't looked at this about guns, so I don't know. My assumption it'd be the same applicable standard as a standard expungement, unless it says otherwise.
I believe, I don't know for sure, but I believe you might have to petition to get them back, even with an expungement, but I'm not positive about that.
Okay.
I guess my thought is if the expungement law is set, that would then allow someone rights for firearms, and they have a means mechanism to do so. I don't know if we necessarily need to deal with that in our language going forward.
I do not think the automatic expungement changes your firearms possession, right? So that's one of the reasons law enforcement can still access those records.
Yeah.
But what if we tied for 152 crimes? I don't know them just as off the top of my head. For 152 crimes, if somebody's eligible under the automatic expungement statute, they're eligible to carry a firearm.
So in the
Legislature's
petition,
already kind of decided whether people need to know about those or not.
Okay, it's Amber's turn. Go.
Yeah, I think the purpose was to kind of inform, should it be in the list, is kind of, and by looking at how the legislature's treated it, those offenses in various ways, whether it be eligible under a stay of adjudication, 15218, or expungable. I mean, even if it's expungable and you can get your gun rights back, it would still, we're talking about, you still have to go through a process to do that, but we're also, this is like a classification of what is a crime of violence, right?
Yeah.
Is kind of what we're talking about. So I was just looking at that to inform what might be appropriate or not, given what how the legislature views each of those offenses. So I'd be inclined to go with, I think, that C option.
Yeah, and Rob brought up a point here that even after expungement, the expungement order has to say that if the crime being expunged is a crime of violence, you still can't possess a firearm or ammunition for the rest of your life. Oh, should say ammunition, it just says firearm. Okay, so Judge Harris, sorry, go ahead.
No, I was just going to say, I like the symmetry of the 15218. I do think you can look at that two ways, because if somebody's eligible for a statutory stay of adjudication and they ultimately have a conviction on one of these, it either means that they flamed out on probation or they had a second offense at it. But I agree, if the legislature has made a determination that these offenses are of such a nature that you can get a stay of adjudication even over a prosecution objection, that does, to me anyway, tend to weigh against it being classified as a crime of violence.
I will say I did extrapolate a little bit on this because it's clear that the legislature hasn't updated this in a while. So, for example, it doesn't mention any of the cannabis offenses. So following the pattern, I included cannabis sale, but excluded cannabis possession, because that's the pattern, is they were including drug sale offenses and excluding others. So I just don't think this list has been paid attention to recently. That's why. So C does not match up with the list perfectly. Just want to put that.
Sale does include possession with the intent to sell as well.
Yeah, that's a very good point.
And I believe the cannabis or possession crime is a 5-10-year charge, which is like a 5th degree.
Yeah, but so is sale, and so is the.
No.
Yeah.
But I'm only saying, 15218 doesn't cover everything because they haven't changed it, but because that was new legislation for the cannabis. But
right,
that is a logical extension what you did to include the sale in what is covered by C, exclude the possession, which is more like a 15218 crime.
So Amber, you got an.
Yeah, I was just, I believe, I mean, 1st degree cannabis sale, I think, is ranked at like a old 5th degree level for drugs in the drug grid. But
it is
sale at that level and that amount would implicate, I think, the potential for a weapon to be used in that. So I wouldn't have an issue with cannabis sale being in there, because it's a high level in which they charge it to begin with. You have to have a lot.
Well, and it's a really interesting statute because it's the same quantity for all levels of the sale but it just piles on aggravating factors. So by the time you get to the felony level, there are some pretty interesting aggravating factors that don't have them committed to memory. But yeah, that is a good point, Amber.
So can I clarify? I have just a clarifying question. So basically C is a mirroring the 15218, like it's the
it's
opposite of it.
yeah, it's kind of like inspired by, yeah, it's inspired by the 15218 list.
With a couple of changes
With-
because that list has not been updated.
Yeah, with
Okay.
with a couple of changes that were intended to, you know,
Yep.
get at the heart of what they were intending, you know, including, so not including any sale offenses, but yeah, excluding some of the more
Okay.
serious possession as well.
Okay. I could support that. I like that idea.
Okay. And Shane, I think it was honestly our conversation that started the C category. Do you have any, did I miss anything in the C offenses? Is this about what you were thinking?
Yeah, that's what I think they are. I mean, it covers all the sales, first and second degree possession or sale, importation, and the manufacturing.
Mhm.
Think of those as the crimes that should remain.
Yeah. Okay. So I guess any objection, I don't know if we need a vote or what, but I could just write up C. It sounds like, anybody object to C? Can we all live with C?
Can I ask a question about it? This is
Yeah.
Amber. Are we talking about as we had that we would say, for instance, this is what we would recommend, or are we
Well, yeah, this would be, so this would take the form of a legislative recommendation, with, you know, it kind of as a package is how I would see it. And, I'm assuming that if it's like anything else in life, that there will be parts of the package that some people hate and parts of the package that some people love. And the idea is, when we put the package together, is it an improvement over current policy in terms of you know, public safety and all the other metrics? And that's what we're going to do at the next meeting, among other things, is kind of come up with, kind of walk through what we're coming up with here and putting it to the same test that we put the status quo to. You know, does this, how does this do with respect to Ashley's metrics of what a good crime policy should include?
okay, so this is separate that from the guide, anything we might submit with the sentencing guidelines for the enhancements for the 60911 crime of violence list. That, I guess that's where I'm.
It's a separate recommendation, but it would be all part of the package. Yeah, it would all be part of the package. The difference between this is it would go into effect, or the recommendation would be to put it into effect August 1st of 2027, as opposed to August 1st of 2029, which would be the case with the repeal of 60911 and so forth.
Okay.
Okay. So what's so now here's the off ramp. That's the other big question with 624. You want to take us to that one? So right now there isn't right now the status quo is D. It's no automatic off ramp. So anybody who has an adjudication or conviction for a crime of violence, and I should say one thing: if the legislature adopts the recommendation that we just made, then the way they've interpreted laws in the past, that the list would change immediately, and that would affect people's gun rights immediately. So if somebody had a prior 5th degree possession conviction from, 1979, that would still that would no longer disqualify that person from firearms possession. So we need to keep that in mind when we think about this as well. But let's now say it's a 5th degree sale. That person who committed the 5th degree sale in 1979 would be ineligible to possess firearms or ammunition for the rest of his life, subject to a 5-year mandatory minimum penalty. But there is an application process, so people can apply for and it's really up to the discretion of the judge. There's no, I haven't found a case where a judge's discretion was overturned by the appellate courts. Pretty much, it's whatever the judge thinks goes. So and I don't have any statistics for you on how many cases there are where there's an application and how many cases where those applications are denied. But it is a process to go through, and that in general tends to support people who are good at manipulating or maneuvering through the court system. So that's the status quo. There are some other options. Option A is the pre-2003 to 2005 approach, where there's automatic restoration 10 years after restoration of civil rights, provided there's no subsequent crime of violence conviction. That had the virtue of being simple. The next one would be this crime-free period. So this is actually more strict than the pre-2003, 2005 approach. There's automatic restoration after 10 years for juvenile adjudications, or after restoration of civil rights plus 10 years with no convictions or confinements for adult convictions. So for juveniles, my thought on that was, it doesn't even make sense to talk about a new offense because they haven't had an offense yet. It's just an adjudication. So I think it just makes sense to call that a 10-year clock. It's a little questionable even to have that be a trigger, just a juvenile adjudication. But if you are going to have it be a trigger, I think just a hard sunset of 10 years makes sense. That's my argument. Or have a 10-year crime-free period where the data would show us that they're really not a public safety risk if they haven't had any convictions or confinement for convictions. C would be some other, fill in the blank option for an off-ramp, or just D, leave things as they are. Dale.
Yeah, I refresh my recollection. You had the graph showing, kind of the bell curve of recidivism. Was that only crimes of violence, or was that all convictions?
Rob, can you answer
that? You're asking about the graph that I showed last time?
I believe so. And I think it's been in the materials a couple of times, but it dealt with, essentially there's diminishing returns on the ban when you get further downstream. And I can't remember if that was all convictions or just crimes of violence.
It was all convictions. So basically, once you get to about people that get to about 7 or so years without a new conviction, their likelihood of a subsequent conviction after that point. These are people with crimes of violence in their past, right? So people that get 7 years or so without a new crime at all, new conviction for anything, misdemeanor and up, the likelihood that they're going to get another conviction after that point is really low. It's very, very low. It's and I think we're all pretty, within the first 3 years is when you're going to get most of the recidivism stuff. And it does not count when they're in prison. So like if they're in prison or jail, the clock starts once they're released. in the community.
One quick thing to ask about that, Rob. Does that time window then incorporate any probation parole, or is it when they off paper in there as well?
Any time that they're in the community at all. So if they're on probation, that would count as the time in which they're being not committing crimes. Sorry, I couldn't think of the word.
So the just a couple of things I would say about this. The pre-2003, 2005 approach did not include the discretionary judicial path off, right? So that was created when they made it a lifetime ban. The extended waiting period is, I said it was kind of more onerous than the pre-2003, 2005 approach because it requires a 10-year crime-free period after you're released from conviction. You know, after you're released from your sentence, you have to be in the community for 10 years without picking up a new crime. It does not take away that discretionary approach. So it's a little bit, you know, it's kind of balanced in a way because there's still the discretionary off ramp if a judge wants to let you out early, but there's the automatic off ramp. So if you're not sophisticated enough to know how to file one of these petitions, you know, all you have to do is remain crime free and you'll eventually get your gun rights back if you can do that. So I just wanted to point out that difference there. So B is a little bit less harsh because it still allows the judicial restoration process, but it's more harsh because any new conviction will restart the clock. Amber?
And then, so if I'm understanding this correctly, the chart and data that we saw would include the probationary period, which, unless, at least for people who didn't have a prison sentence or a long jail sentence as part of their sentence. So we're looking at, if it's 7 to 10 years that we were looking at on that chart, when we're looking at B or even A, it would be more like 13 years if it was a felony conviction because it's saying restoration of civil rights. So it would be after probation has been successfully completed and discharged. Am I understanding that correctly?
I would have to look at that.
Well, you'd get the restoration of civil rights when you're discharged from probation.
You do. I'm just trying to remember how it was worded before. I know it's still worded that way in one statute, so I'm going to look that up.
Would it be helpful to show the graph again?
And Rob, yours, they could be on probation though, right? As long as they didn't offend.
Correct.
And they were out in the community. Okay.
Yeah. Just to show you the graph again. So basically the way to read this is it's the risk at any certain point. And so when you see the people that are like in this first year and a half or so, you know, basically what that is saying is out of the people that have made it to this point, roughly 32 or so out of 100 will pick up a new conviction based on an offense at this, you know, somewhere around this point. But then once you get down to 10 years or so, it's of the people that have made it in this group, 2 out of 10 of that group will maybe get a new conviction within the next year. So in other words, you know, we're talking about pretty small numbers. And if it ends at the time of discharge of whatever previous sentence, so like if it's the end of probation or it's the end of supervised release, this would actually we'd be looking close, however long that is, but it would actually be after this, what I'm showing you here. So it'd be more in this kind of region towards the bottom right.
So I'm going to put in, so this is the language that still exists. This is kind of like the artifact. It's in 609.668 explosives and incendiary devices. But this is the old standard, and for some reason it didn't get changed here. So this is our archaeological evidence of how it used to read. So it's a little bit it's not quite what it says on the chart, but so it's 10 years have elapsed. Oh no, maybe that is it. So 10 years have elapsed since the person's civil rights have been restored or the sentence is expired, whichever occurs first. And during that time, the person has not been convicted of any other crime of violence. So aren't the civil rights normally restored upon the sentence expiring? Aren't those kind of redundant?
Well, it depends on what you mean, because restore the vote moved the voting restoration part upon release.
Yeah, well,
I
609.16.
don't know what other civil rights there are other than that.
Well, 609.109, 165, I think, is the main restoration statute. And it says when you're discharged, it says when you've been convicted and then discharged, the discharge order restores you to civil rights.
I think that allows it to take into account early discharge. So expiration would be you made it all the way to the end of your sentence. It's over and it's automatically over, whereas early discharge is an action the court takes to release you sooner.
A discharge with a stay of imposition always has that language in it. The court order does, that your civil rights are restored too. So it would take into account sentences that are stays of imposition, where you're technically not sentenced.
Okay. So, I mean, let's, I guess, start the conversation. Do people think there should be an off-ramp? If so, what should be the off-ramp be? Do people think lifetime with judicial discretion, that's an adequate off-ramp? Anybody want to speak in favor of the status quo, number D?
That'd be me.
That'd be you, okay.
Yeah, I mean, if there is an automatic off ramp, what we're saying is that second-degree murder, you should automatically get your rights back after a period of time. I think there are cases that they should have to go in and prove to a judge that they should be entitled. It shouldn't just be an automatic thing. And I like the idea with judicial review of an individual person's situation.
Yeah, I guess maybe I got a little confused. I was thinking we were kind of still kind of dealing with the 152 if we take that out or however we're going to deal with that. But I gotta say I'm with Shane on this one, that a majority of these I think need to be reviewed, and their petition to the court should be going through that process if they want to restore their firearm possession.
Okay, so we got 2 for D.
I will agree with Shane and Jeremiah on that. D.
I do too.
That was Nick.
Yep, that's correct.
Nick and Ken. So we got 4 for D. And Dale put
I would
up.
go for A. I would go for A or B. I guess A would be my preference. I just think if they committed a more serious offense, they're going to do a longer sentence for that. The 10 years doesn't kick in until after they've completed their whole sentence. My
And
thinking on it.
Dale put in the federal law. It's my understanding, and I did talk to the, I don't know if I can say who I talked to, but I talked to nonpartisan legislative staff. And it's my understanding of the federal law is there's deference to state law. So if state restores firearms rights for a felony, then the federal law will also restore the firearms rights for the felony. So it's kind of state led. And that's not true of misdemeanor crimes of domestic violence, by the way, but it is true of felonies.
Yeah, that's been my understanding too, and I've had to research that issue for gun permit cases.
Yeah, and I just wanted to bring it up just in case if that's the practical effect, I'll certainly defer to the people who've done the research on it. But every time I signed off on one of those probation discharges saying your rights are restored, I always felt funny about it because I knew there's this provision of federal law, and
Yeah, there's another provision. I don't know if it's in 921 or 922, but there's another provision that says that basically a state restoration of civil rights, including gun rights, negates this.
these particular federal statutes are not a model of clarity, by the way. I say that among friends.
That is very true.
They weren't all written at one time by one person in their defense. They were, okay. So we've got some for A or B. Amber.
I would support A or B, and I just want to note like an equity issue that I see with this, because if there is an indication that the group as a whole thinks that the lifetime prohibition in and of itself is maybe needs to be reconsidered, having access to the courts and filing that petition and then petitioning for your gun rights back puts some people at an advantage over others who have the same exact criminal history, and resulting in one person being able to own a firearm legally and the other not, and having subsequent criminal prosecution against them. And so I don't know, there are barriers here without an off ramp at all that I think we should consider.
It's kind of how I see it, Amber, too. And the thing I like about the 10-year crime free is one, it's very supportable by the data, and I like being data driven. And it's also really hard for a lot of people to stay crime free for 10 years. I mean, for some people that would be a momentous accomplishment to stay crime free for 10 years, and sort of an unimaginable one. And it's something that I think some of us aren't really in touch with folks who come from that kind of a background. I'm reminded one time of I needed to get something out of my trunk, and I won't say who was in the car with me at that time, but so I pulled over on Cliff Road in Egan, and eventually a police car came up behind me and asked me what I was doing, and I explained it, and he drove off. And my passenger said, "That is the first time in my life that I've ever been in a car where a police car pulled up behind us and somebody didn't get arrested." And I think that's the kind of person we need to think about. Like, for that kind of person, the 10-year crime-free period would be an immense accomplishment. And to me, it's unfair to particularly for juvenile adjudications to just say that person can't ever have firearm rights unless they figure out how to go through this judicial petition process. Honestly, it kind of reminds me of the recent Supreme Court case where a marijuana user, it's unconstitutional basically to say that just because somebody uses marijuana, that they therefore cannot possess a firearm. So, but I am concerned about the votes here, though, because if I'm counting right, we have 5 Ds now. How many of us are there?
I would still vote B, I think, because like you said, it's data driven, and I think it is putting a pretty significant procedural hurdle up, as Amber talked about.
I would vote B.
I guess I stand, or I would support B because I mean, I think the data supports this in terms of in terms of like propensity towards later violence. I mean, all the research, it's a pretty pretty robust finding in the research that after people go 6, 7, 8 years without a new case, just the likelihood that they're going to engage in more crime or more violence is just really low. And I mean, it's just like it's about it, it gets to the point where it's almost as low as just the general public who's never had a case before. And I'm not a gun person at all. I never have been. And so but I do know a lot of people who are, and I know a lot of, and I think if we think guns are useful for, protecting, for protecting your family or for hunting or for any of those things, that's the kind of stuff where I think, I mean, I don't know. I guess that's where that tells me that we should, if we're just holding guns from people just to hold guns from them, I mean, I think we have to have a reason, and I don't really see a reason for the lifetime ban, especially if the propensity is very, very low.
And I think the case that that's going to come up is somebody who's been crime free for 15 years. And it's pretty obvious to everyone that if they had made that petition, it would have been granted. And it's just like, oh, I forgot to do that. And, yeah, that's putting the burden on them to do that process. But are we really enhancing public safety by making that hoop something that they have to jump through?
Yeah, I could support B as well.
Well, I'll be a B.
And I think it's okay to not have full consensus.
No, it is. It is. I think that's worth noting, though.
Yeah.
If it's a consensus recommendation, except for one that's, a mere majority recommendation, I think that's worth pointing out in our report. Amber?
I just wanted to add, I mean, gun rights are something that clients care a lot about when we're trying to figure out how we can get this case resolved. There could be an incentive here too, to people that they can earn their gun rights back. If they can remain, that would be part of the equation if you are making a plea to something that is going to take your gun rights away. It's not forever as long as you can remain law abiding. And that could actually be good for public safety.
I guess, oh, sorry, I should probably raise my hand. Okay. I feel like there are a lot of really valid points that people are making. I mean, I guess I'll just be honest, as someone as like a victim rights advocate, it's kind of hard for me to vote in a way where someone, wouldn't have this extra review. At the same time, I'm understanding that, the data may not necessarily support my hesitation. I do think, guns are used in homes, differently than they are used in public, and that like concerns me. Um, but I guess what I'm trying to say in all of this is like I'm a little bit with you, Vashti, and I understand why we would land on B as a group, even though I'm hesitant myself to go there. I would support. I'm understanding that there are more pieces of information that a reasonable person would say B, even though it's hard for me to say that based on where I stand on things.
Sure, fair. Jeremiah.
Yeah, I mean, I guess I can kind of see where people are coming at, when they look at B as an answer, to kind of resolve this, and we look at, the inequities and access and those sorts of things. And part of me, though, again, I'm just going to be reminded, if we look at some of these things, we're talking about people that have committed murders, right? We're talking about people that have used weapons in the past for aggravated robberies, and while yet likely their recidivism rate, goes pretty much next to nothing after that 10-year off ramp. I still think, as a person coming back, with society and that sort of things, to be able to say, you know what, I do want to be able to lawfully possess firearms. Those are some steps that you have to take. You've been found, convicted in a court of your peers for these types of violent crimes. And, that might be just that extra step you have to take if you choose to want to possess firearms. If you know in your life, like, you know what, not my thing, never going to do it anyway, then you don't care. You don't need to. And so I just don't see where somebody who 15 years down the road is like, oh, hey, yeah, I'm going to go hang out with firearms now, and I'm making this decision to do so without taking the correct steps. I think somebody at that point in their time in their life, is going to be able to have access to that, whether it's they're using free clinics through Hamlin Mitchell, or whether they're using clinics through county attorney's office, self-help places. It's not a huge hurdle, I don't believe, to get that ball rolling if you have the internet and a form, or you can walk into your local courthouse, get that form, fill that out, and file the paperwork with that court. I just think it's something that to just off ramp it to say you automatically get it back. I think you got to you have to show that you have the knowledge, the ability, the resources, and wanting to continue not using firearms in a manner that you shouldn't be, or you choose not to and you don't go get it done.
Okay. Any other, do we have the votes complete? Is that?
Yeah, we're like in the middle, a little bit more would be.
So
Mostly, yeah.
What's the
right.
tally then?
We have, let's see, 1, 2, 3, 4, 5 Ds, and 1, 2, 3, 4, 5, 6 Bs, with Mark being A or B. So that would be 7. If
Well, we take that then. So 7-5 right now. Keep in mind, these are all preliminary decisions, right? So we'll see what the data says on these. And actually, I'm not sure what even to tell the folks about the 611 thing, because it's up in the air. Maybe you and I can talk about that afterwards. But certainly this is something that we'll be able to hopefully come back with some data on. Oh, Jeremiah, yes. Is your hand still up, or do you have a new point?
My bad. I'll keep putting it down here. That's my
okay. Yeah, no problem. Yeah, I just want to add one personal anecdote. I was because I'm thinking now about that guy in the car. I've known him now long enough that I've known him. He's been crime free for 10 years, and I got to say, the person who he is now is nothing like the person he was 10 years ago. It's just not even close. And Okay, so we're on to predatory offender registration. Okay.
So we have, let's see, 4.5 more decision points to make, or to go through. These are about predatory offender registration. The first two are similar. One is about the first offense minimums, and the other one is about the second offense minimums being changed. So for background, as you might see on page 9 of your document, the statute required is that certain individuals convicted of specific serious crimes, or if they're adjudicated, they have to register with law enforcement as a predatory offender. They also have to provide updated address, employment, vehicle, and other identifying information. And third, they have to comply with long-term reporting requirements, often 10 or more years, and in some cases, lifetime. So decision point 3.1 is about the minimum for the first offense, and should this be changed?
I'll just say, I think that I'm going to speak in favor of A. I think when you have an offense, a mandatory minimum that's as highly departed from as this is, particularly with a group that you're asking to respect the law by following all these rules, I think, when they see the mandatory minimum departed from at such a high rate, it does not engender respect for the justice system in general.
I talked to our, I'm sorry.
Go
Real
ahead.
quick, I talked to our POR experts at the BCA and ran a lot of this by them, talked to them. So their preference is B, but also note that they're going to propose some language changes, some statutes that they're working on right now through the BCA. So my preference right now, or my vote is B.
Can you give us a hint? What are they proposing?
They're working on the language yet, and I don't have the final version of what they're proposing.
I lean towards A, just because I think these things should be sent to the Guidelines Commission. I think this is a guideline. This should be to me, this should be a guidelines. The guidelines can do a presumptive commit even for a year and a day or whatever. And so I would support A, because if it's already departed from as much as it is, then I think we leave it up to the Guidelines Commission.
Judge Harris?
Yeah, I think I've said all of this in prior meetings, but I have two. I would support A for two reasons. Number one, I think when you have departure rates as high as this, it's showing that the current scheme really isn't accomplishing what it's intended to. And I also, at least in my experience, the vast majority of the cases that I was seeing were people who had unstable housing. I saw very few of these cases for people that had a stable address. And it takes some folks time to get traction on probation. But it's I think this is not enhancing public safety by having a bunch of presumptive commits with departure motions that have to get litigated through. So I would support A.
Jeremiah?
Sorry, I wanted to take my head down first, otherwise I'll forget. So I guess I could see myself going into the A category, but I would really ask that we as a group kind of differentiate the kind of what I would say that first time offense because of housing issues or something along those lines. However, if their first offense is active evasion or something like that, where they're fraudulently putting their paperwork in or kind of avoiding the registry as it's intended, then I would want that to be defined to allow that it would still be a mandatory minimum if they're making an intentional acts to avoid the registry versus circumstances around, homelessness or that sort of information.
Yeah, which it's hard to do right now because of the way the law is written. It doesn't make those distinctions, and maybe that's what the BCA is getting at. It would be interesting, and I'm not saying we should support something we don't support, but by having this recommendation out there, it's possible that could put a little pressure on the BCA or somebody to make some meaningful distinctions about between the people who are couch surfing and forget to list their latest couch and people who are actually endangering public safety. Shane?
Well, this might be a regular man bites dog story, but I'm more in the A camp on this. Some of the reasons, many of the other offenses in the criminal code use the second time offense as the one that's the more mandatory. You have DUIs that operate that way. We've seen the drug ones that are that way. The second time seems to be more the trigger there. That's one reason. I know practically it gives prosecutors less discretion. We have a harder time because it is such a huge one size fits all that our options are other crimes or stay of adjudication, which isn't the most effective way to deal with them. This dovetails, my third reason dovetails into that, which is the statute is so broad and covers so many different kinds of behaviors that are a violation. This is where I like Jeremiah's comment. It's like, if it was actively something involved with not saying where you live, leaving aside issues of homelessness and the problems there, but versus vehicles and so many other things and just the timing of it. And by having too many things lumped in is probably why you're seeing such a high departure rate, because so many of them don't make sense. And then fourth, I think this was something Ashley said at a meeting quite a while ago, is there's something kind of problematic in my mind that some of the offenses which get you on this list themselves are presumed stays, like some crim sex crimes. So we're saying that not saying where you live is, or what houses or cars you have, or those things is worse than sexually molesting a child or other non-consensual felony crim sex crimes. That seems to have it backwards.
And to that point, I would just say this is currently on the sex offender grid, and it kind of it looks funny on the grid because it's the only non-shaded row that's at the bottom of the grid. All the rest of the non-shaded rows are at the top of the grid. But this is the least serious offense on the sex offender grid, but it's non-shaded because it's a presumptive commit the whole way across because of the statute. All right.
I have a comment. I would vote A as well. And just sort of Jeremiah, to one of your concerns is just because if we were to say that this is now no longer a presumptive commit to prison, doesn't mean that for those more serious offenses, the prosecutor couldn't file a motion for an aggravated departure if it was, really fraudulent in what they were doing or the facts were bad. They could still say, hey, I actually want this to be an upward dispositional departure and try and prove that. So it's not that all of them would be that way. There would be, I think there'd have far fewer departure motions that way instead of 60% of these getting a downward dispo departure motion. You'd have a couple that could be upward. So.
It appears that I'm signed into WebEx on the Sentencing Guidelines account. I just want the record to reflect that I am not speaking on behalf of the Sentencing Guidelines Commission when I vote A.
So we have 11 A's and 1 B.
All right. Okay, and that's everybody who's here today.
Correct.
So, okay, good. So this might be a little more controversial. How about second offenses? So currently that's a 2-year mandatory minimum. The recommendation of the Predatory Offender Statutory Framework Working Group was to make that the year and a day mandatory minimum. And I just a little inside baseball on how the sentencing guidelines work in conjunction with the year and a day mandatory minimum. Essentially, it'll be whatever the duration is. It'll be a presumptive commit. So it'll be, more than a year and a day, depending on the criminal history, but a year and a day is kind of the starting point there. So that A was the recommendation of the 2022 statutory framework working group. B would be to abolish the 2-year mandatory minimum as well. And C would be keep it and keep it as a 2-year. So A is keep it and keep it as a, but drop it down to a year and a day. Basically say prison for however long the guidelines say. B is get rid of the 2-year mandatory minimum as well, and C is keep everything as it is.
I don't remember the presentation on the second offense. Was there a high departure rate on these as well?
It's in the January meeting materials. I'd have to look it up. I know it's a lower departure rate than the first offense.
Makes sense.
And I would, I will say I support A because, it addresses some of the concerns of the minority report in the 2022 Predatory Offender Statutory Framework Working Group, which is, it may be that we'll get enough data someday to say we should abolish this one as well. But I think in terms of the concerns about the impact of abolishing the first time mandatory minimum, if that doesn't pan out, then maybe we can get rid of this too someday. But I think because we should be cautious, I support kind of this incremental approach of keeping it, dropping it down to a year and a day, and let's see what the data show us in the future about compliance, about departures, and all that.
I guess for all the reasons that were discussed for the first time, I think I would vote for B. It's still a felony. We can't forget that. Maybe we could recommend an enhancement. I'm not sure exactly how that would work, but I would vote for B. Or make it willful, as was suggested, but that can be difficult to prove.
Shane, what do you want to say?
Oh, thank you.
My recommendation is not one of the 3 options. First, with regards to use in a year and a day, is we run into the issue of the duration being what we've seen on other aspects where the duration doesn't match the criminal history score and the various scores that you have. So I'm looking at the chart. Once you get to 2 points, that's below that amount. This is like the knife weapon charge and the drug ones and others. My proposal is that you keep the mandatory minimum, you reduce the duration to what is in the grid.
Kind of like what the drug offenses, some of the drug offense, not the repeat drug offenses, but the first and second degree drug offenses that aren't repeat.
Right. So if someone, if they have 1 criminal history point, that starts off at a year is the low end of the box. But if you're at someone with 6 or more points, that's 31 months low end. So you use the guideline durations to guide the duration.
Mm-hmm. I mean, I'd be fine with that if If you can convince the rest of the group, Shane, I'll join you on that, but otherwise I'm going to stick with the majority. But I don't think that's unreasonable at all.
To me, it seems disproportionate to the actual behavior at, that issue was not registering. To base that off of criminal history, and I get that there's some logic to that, but it seems like for what they're doing at that particular moment, it might be overly punitive. And their history could be based on a whole bunch of different things. It could be a long history of, low-level drug crimes, or not necessarily violent or criminal sexual.
All right, I'm still trying to find the data.
Oh, it's I found it. Just for the data question. First offense, the mitigated dispositional departure rate was 54.7%. For a subsequent offense, it's 43.3%.
Thank you.
Did we have any data surrounding those that got afforded the departure for the first time? And then did they reoffend for a second time? Do we have any data to show like if there's significance in that, or is it just 1 and 2?
We didn't do that analysis, and I don't recall if the 2022 predatory offender, I know they got pretty deep in the weeds with some of this stuff, so it's possible they looked at that in the 2022 report, but I don't specifically recall. The number of cases is interesting, though. There's during the from 2018 to 2024, there's 1,734 first-time offenses and 510 subsequent offenses. So it definitely goes down.
Yeah, I guess I would just like to know that the 500 that reoffended, if they were provided that downward departure, if we have a significant amount that were given that second opportunity yet still landed back in the same position versus the reverse, right? Where actually these are the ones that didn't get it and they're ending back up. Ballpark of reoffending again.
So we have mostly A's. We have 1 C and 2 what I'm going to call D's, which are Shane's, and then 1. Jeremiah, I didn't see if you put a vote in.
I didn't vote in yet. I guess
Okay.
I'm going to have to go with, based on how we have the things and the facts that we have set up. I'm going to kind of fall in line with Shane, I think, on kind of utilizing that criminal score that we are already kind of going after and utilizing to establish safety. So
Thanks. So we have 3 D's, 1 C, and 8 A's.
So we got everybody's vote. Okay. All right. Very good. We're getting close to the end here. Okay. And this is a general question regarding mandatory minimums in general. But the boilerplate on these mandatory minimums is that the prosecutor can petition for waiver of the mandatory minimum, and the judge on the prosecutor's motion or on the judge's own motion, but not the defense attorney's motion, can waive the mandatory minimum. And this is a point where I think Judge Harris made the point that it really puts the judge at a disadvantage when the judge isn't allowed to get pleadings from the defense side on the petition for the waiver. And it just seems unfair that the defendant can't petition for something that the prosecutor can petition for. So, anything you wanted to add on that?
I think that this also, I know I've been banging this drum since I think we started
Yeah.
in this committee, but this also can really just jam up plea negotiations where, you know, if you have these mandatory minimums, unless the prosecutor is going to agree, if they say no, then we're going to go to trial. But if they say, you know, no, but the defense can still move for a departure, then they can just enter a straight plea and take their chances. And we would have fewer trials this way. And if it's appropriate, the judge will decide it. If it's not, they'll say no. But, you know, again, this just started as a weirdo statute that only said the prosecutor, and then people got mad about separation of powers, so they added in the court, but not defense attorneys. But I really think this would, you know, result in fewer trials if we were to allow this, and just more fundamental fairness.
Yeah. Yeah, I don't see why it shouldn't be either party. Judge Harris.
I'll just stand by my earlier comments, which I think you accurately summarized. I do believe I've never understood why the statute was structured in such a way that the defense couldn't make that argument. We allow them to make departure arguments on pretty much everything else. And if it's a meritorious argument, the judge can grant it. And if it's not, they don't have to. It's just giving that option, and just fundamental fairness to me seems like they should be able to do that.
Oh, I'm an A
Yeah.
for the reasons the judge said.
We just have Nick and, okay. And then Jeremiah, sorry if I missed. Okay, great. So we have 11 A's and 1 B.
Okay.
It's the same as what we just.
Oh, yeah, we did this, right?
Good.
Yeah, in a different way.
I made different for,
Oh, it's a different one?
this is 3.
Well, we resolved these issues, so. Okay. Well, I look at that. We're done. So anything you want to say in summary, Julia?
Yeah, I think for the meeting on the 10th, next week from tomorrow, we'll work with you two to figure out the summary and summarizing of stuff too. But I just want to come back to these, our key duties of what we're going to be making sure that we've checked off in the report and that we've covered, and especially going through what I think you referenced earlier, Nate, about Ashley's grid that she put up a few months ago, and kind of checking back to make sure that we're covering all those grounds with all the great discussion that's happened over the past couple of meetings. And then I guess the other thing, just which I'm kind of moving into a different part of the agenda, so I'll just let Mark ask his question.
Yeah,
and
go ahead, Mark.
Oh, not knowing what you're going to move to, I'm not sure if it's the best time, but I was wondering, I think we're going to take some kind of vote at the next meeting, right? And on the 60911 decisions, it seemed like there was, some folks that wanted to have something that we would, in our recommended legislation for the sentencing guide, to initiate sentencing guidelines commission work, that we would retain some kind of a mandatory minimum, maybe at the level 5 or something, up there. And I just wanted to, I would want to be able to consider that. Although personally, I'm basically against all mandatory minimums. I think that's what we have judges for. I think, I agree with some that what we're proposing might be a lead balloon without something like that, particularly for repeat offenses. Does that make sense?
Yeah, I mean, it's, and part of it, I mean, I guess to me, maybe I'm thinking about it all wrong, but to me, the difference between a mandatory minimum and a presumptive commit under the sentencing guidelines is almost semantic, because if the mandatory minimum is waivable, the waiver criteria is always the same as the departure criteria from the sentencing guidelines, which is, can the judge, who's, by the way, a law school graduate and probably knows how to write, can the judge articulate substantial and compelling reasons for departing from A, the mandatory minimum, or B, the sentencing guidelines, or C, both? And so yeah, I'm not sure
well,
I mean,
Shane had mentioned the mandatories for drug offenses. We called them the kingpin offenses, where that they are somewhat tied to the guidelines.
They are, yeah, they are tied to the guidelines, but those are, well, some of them at least are also non-waivable mandatory minimums, and that's something we didn't really talk about with 60911. But
I hear what you're saying about semantics, but as you know, in politics, semantics often carries the day.
So you're saying that it might be a good idea to create a statute that says that
well, let me put it this way. I think what we're proposing puts legislators in the position of voting to revoke all mandatory minimum sentences on gun offenses. Right?
Yeah, no, I hear what you're saying. Right, and I guess one of the virtues of the previous proposal that I come up with, that was, you never had to say revoke, you could just say replace.
Right.
We're replacing 60911 with this new and better statute that looks at criminal history and offense severity like the status quo does not do. So I appreciate your political sensitivities there, Mark. So maybe I'd draft something that basically says that whatever the Sentencing Guidelines Commission establishes here, that those are mandatory minimums, kind of thing. Is that what you're thinking, Mark?
Well, maybe, yeah, you can get creative that way, or somehow maintaining some form of a mandatory in the proposed legislation that would retain something for a mandatory, like what we are currently calling a mandatory for the highest level of behavior. And we don't have a lot of time now, but like if you can come up with something like that we can have something fairly concrete to vote on, that would be nice. I know you've got a lot to do and you've already done a ton.
Amber?
I was just gonna weigh in on that. The way at least the way I understand that we have it structured, is if it's tethered to the sentencing guideline, the higher the criminal history, or the more criminal history a defendant has, the high we're adding to their presumptive sentence. So perhaps there's a way to say increase penalties for chronic offenders or something like that, like
mandatory enhancements.
Or mandatory enhancements. There you go. Because they don't get that bite if they have a big enough criminal history, because the mandatory minimum is eaten up by their presumptive sentence according to the guidelines. So I think there is a way to present it the opposite way, if that makes sense. In that we're enhancing people who have extensive criminal histories are going to be serving longer sentences under this new framework than they would with the mandatories.
Yeah, good point.
Yeah, I mean, I think you're still, well, so I guess what's the takeaway from this discussion in terms of what we need to draft for next week?
I think I'm
Well, what we
hearing.
left it from the previous discussion was, as I understood it, what you'd be drafting is a recommendation to the legislature that they revoke 60911 mandatories and direct Sentencing Guidelines Commission to create an alternative with some parameters. Is that accurate?
Yeah, pretty much.
Yeah. And then what I'm proposing is, along with that, if you could offer some language that would retain a mandatory sentence, maybe similar to existing or that at the highest, like a tier 5. And I don't know for others that spoke up before about, wanting to retain some of that, the higher levels. Do any of you have thoughts?
Like a waivable mandatory minimum or a non-waivable mandatory minimum?
I'd support a waivable one.
Well, I mean, I think that's sort of just, we're circling back to, if it's waivable, we're getting back to the same reasons that you would have a departure. And a lot of these are just going to be presumptive commits.
Yeah, if I'm off here, that's fine.
Well, like I said before, Mark, you've been in the Capitol a lot. I appreciate your political sensibilities.
Well, I was going to say that it's possible. I mean, we could also draft a couple options, and sort of look at what do those look like and where do we fall.
Okay.
Yeah, that's what I was requesting. If that's within your ability to make a couple options.
Sure, it is. I will tell you this, and it probably, given the holidays, would have been a pipe dream anyway to expect that the reviser could have turned around, that I could have written something up to capture today's meeting, gotten it to the reviser, and the reviser would have turned it around by next Friday. So that won't happen if we do the options. And that'll mean that the first time we'll see the reviser's options, the reviser's language, hopefully, the first time we'll see the reviser's language will be at the final meeting. But, that should be okay because the reviser should be just implementing the language that I'll show you next week, but more cleanly.
Yeah, so what you're saying is we can look at it next week the clean, easier way, and if we want something else drafted, we can still do that for the August meeting.
Right.
Yeah, that sounds like a plan.
Okay.
It doesn't sound like we have much choice.
Okay, very good. All right. Well, I'm going to say we're done with 3. Now it's time for Wilder to discuss the timeline for the report.
Yeah, so we have, and I think I say this every time, recently we have a working document with a lot of placeholders. More recently, we put in MNJRC's items that they went over the past 2 months. So they have given us a written report and also an executive summary. So those are in process of being embedded. And then we have just, again, a lot of placeholders. So I think the important question we have for you all is how this will be reviewed. Like in terms of who's going to be reviewing it. Is it just going to go to the chair and vice chair, or, we want to know when, because we have to get it copy edited and then also formatted so that it's accessible and all those things.
Prior to next Friday? we're
No,
thinking? Okay.
no, but between Friday, the 10th and, before the August 4th meeting, because we want people to, and we know that if there's going to be things that are coming out in August 4th, that it's just going to be, in the appendix or something, and we're going to be saying, see, language there, that's fine, but there, just, we can put placeholders in there, but we just need to make sure we give time, know what our time frame is and who's going to be reviewing. I'm assuming the whole group won't be doing the final review, and it will be, and we could talk about this in July too.
I mean, it is important to me that the whole group approve the final report. So I've been on task force. I think I've said this before. I've been on task force where the chair just kind of met with the contractor and something came out and I'm like, I don't remember all that. So I just from a process point of view, I want us all to be at the meeting where we approve the final report. But I'll be happy to, I think the vice chair and I can work with you on that as far as editing goes.
So then ideally what we'll have is August 4th, you're going to have the final report. It won't go through the final copy editing yet. So there might be a missing period, that kind of level of things. We'll have what we understand is maybe a placeholder for any language that is going to be updated in there, and then have to update it then. I mean, if you're going to be presenting stuff on the 4th,
Yeah.
Or does that not need to be in the report, whatever the revisor sends?
Hopefully the 4th will be a pretty short meeting. I mean, I'm anticipating just any substantive changes that need to be made to the report will be taken care of then. And we'll be looking at the reviser's language and ratifying votes if people were missing at the July meeting. I say ratifying like they're going to agree with everything, but just basically make up votes for people who missed the July meeting.
Okay, so then on July 10th, we will then have an update about when you will get the report, given that, because then it gives everyone time to read it before the August 4th meeting. So.
Okay, so there won't be a draft report at all in July
Well, we have something that we can share. There's just a lot of holes in it right now, but I don't know. Yes, we can have something on the 10th. I don't know if it could go out 3 days in advance though.
Sure. Yeah, no, I know that's hard. Okay. Okay, and then July and August agenda items. We kind of talked about my concept of August agenda items. As far as July goes, so Mark Osler's not here, but I'm going to be wanting him to walk through 2 of those. I'm going to be wanting you to walk through 2 of those. And two of the 7 criteria, and then I'll do the public safety one. And then Rob, I'm going to want you to walk through 2 of those too. Does that make sense? So whether you want to convene your subcommittee between now and then, or just lead them yourself, or get informal input from your subcommittee. I know you're kind of.
There's not going to be an opportunity because we won't even get the proposal till sometime within the next week.
Yeah.
So there really won't be an opportunity for any subcommittees to meet.
Yeah, it's kind of what I was thinking too. So I think it'll probably we'll have to rely on the committee chairs, and you're kind of the chair emeritus of the stakeholder engagement committee. So that's the capacity in which you'd lead that. Does that make sense?
I mean, I can lead the discussion, but I think everyone's going to have to weigh in on those things.
Sure.
Yeah.
Sure. But just, I mean, if you could just kind of do some pre-thinking,
sure.
So we have something to sort of put in there. And let's see. I don't know. Do we know when Mark Osler's getting back? Is he?
He has not put that information out.
Okay. What else? So kind of reviewing whatever impact information we have in July. Are we expecting any other data in July or any other new information? Reviewing whatever you want to I mean, if you want to just kind of put it up on the screen and kind of walk us through it, not even necessarily give us the information in advance, I don't think there'd be anything wrong with that. If you give us meeting materials, you have to give them to the public as well. But if you don't give us anything
Okay.
and just kind of show it kind of what's the structure and what we're doing and kind of give us a chance to weigh in on that, I don't think that's unreasonable.
What I
Especially,
can do is I can give an outline, and I can provide that beforehand.
Okay.
And then go through the details of that so that people, it's similar to what I showed last time, but I wouldn't expect with all the things we've talked about for people to have that top of mind. So
Sure.
I'll do that.
Okay. Don, are we missing anything on the July agenda that you can think of? Okay. I mean, the main event then will be the vote on this. And as far as the vote goes, I'd like to structure the vote in such a way that, we capture all the unanimous points and, basically we capture those things that are, have the most support, kind of narrow down just so it's clear where the consensus is and where there's a break where it's just a majority but not a consensus. All right. I think that's about it. And so we're 9 to 12 on July 10th. And that's going to be, you want to tell us about where that is?
So you're welcome to come to the Wilder Foundation, which is not too far from here. It's right off of 94 in Lexington. There's a covered parking garage with visitor parking really all over, but especially on the first couple floors. And yeah, it's going to be on the second floor. So there's public access to the second floor and the room is 2510. And if you run into any questions, there's a front desk that you can ask. But yeah.
Is it at 9 or 9:30? Because I think I got an email today that said it was 9:30.
It should be at 9.
It's supposed to be 9. I erroneously put 9:30 to 12:30, so I will adjust that. Thank you.
Oh, good catch.
Yeah.
I don't know if everybody heard that,
Yeah.
but there's an email that
I'll be in there.
incorrectly said it was 9:30 to 12:30. That's incorrect. It's 9 to 12.
Great.
Okay. All right. So public comment. Do we have any members of the public?
We do not have any members of the public online.
Okay. All right. Well, with that, we've completed our meeting agenda. Thank you all for your time and patience to get today. I always like it when things don't go the way I expected because that means you guys are thinking. So I appreciate it. I think this is a good product and I'm looking forward to moving to the end. We'll see you next week. Have a happy, anybody know what it's called? The quarter millennium?
I don't know.
Anyway, happy 4th of July, everybody.